Test one, two, three. Test one, two, three.
Dave, can you hear us okay? Dave? Mic check.
Hello, sorry.
All right.
Can you
cool.
hear me? I
Yep.
can hear you.
Thanks, Dave. We're good. Commissioner Suchman?
And now I'm unmuted.
You're good. Okay.
It doesn't matter how much you yell. If you're muted, no one's gonna hear you.
All right, we got you. Thanks.
It's like a line from a movie.
All right, welcome to the Public Service Commission's administrative meeting for December 23, 2025. First item of business is to approve the minutes for our meeting of December 17, 2025. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barbay.
Aye.
I vote aye.
Morning, Mr. Chair. There are 3 items on today's consent agenda. Item number 1 is a request for an extension from 4771 Gorman LLC. Item number 2 is a notice of change in a trade name from L5E LLC. And item number 3 is a request to withdraw a license renewal application from Greenlight Energy, Inc.
Okay, regarding item 1, I move we grant the requested limited waiver of Comar 20.62.03.04C and extend the operational deadline for the Gorman Road Solar Project to February 28, 2027. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barbay.
Aye.
I vote aye. Regarding item 2, I move we note the filing. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barbay.
Aye.
I vote aye. Regarding item 3, I move we note the withdrawal of the company's license renewal applications and approve the cancellation requests. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barbay.
Aye. Okay, next we're going to move to items in this order 4, 5, 24, and then 6.
Good morning, Chair Hoover and Commissioners. I'm going to address comments jointly on 4, 5, 6, and 24, and so I won't recover that speech when we address number 6. Good morning, Chair Hoover and Commissioners. I'm Phil Vanderhayden with the Commission technical staff. Before the Commission today are proposed community solar tariff revisions from Baltimore Gas and Electric, Potomac Edison, Pepco, and Delmarva Power and Light. These filings were submitted in compliance with Rulemaking 56 and the requirements of recent state legislation, specifically House Bill 908, House Bill 1036, and Senate Bill 931. Our objective today is to finalize the implementation of the utility consolidated billing and net crediting protocols for community solar by the statutory deadline of January 1, 2026. This transition completes the move from a pilot phase into a permanent community solar program, allowing subscribers to manage their solar subscriptions and utility charges on a single bill. The primary unresolved conflict today involves Potomac Edison's request for tariff language that would grant the company unilateral authority to discontinue service to any community solar project that does not maintain the statutory 40% LMI subscription threshold. Staff recognizes the need for the company to be able to follow the legal definition of a community solar energy generating system, which requires at least 40% of the energy produced to be served to LMI subscribers. However, as noted, there is a need to clarify whether the new legislative requirement for banking of unsubscribed energy provides a means to manage a discrepancy in that 40% threshold. Staff believes that treating LMI shortfalls as banked energy for 12 months allows projects time to reallocate output to new LMI customers before a financial penalty is triggered. Several options to mitigate this potential conflict were discussed by the Net Metering Working Group over the last few meetings, but a suitable alternative compliance mechanism was not agreed upon by stakeholders. While the group was able to reach consensus on many items, this issue raised by Potomac Edison remains an area of non-consensus. PG&E and the PHI companies did not propose this language and have not otherwise provided a position on the specific issue at this time, to our knowledge. Furthermore, staff recognized the concerns of the solar community that uncertainty in maintaining projects in the program creates an intolerable risk for project owners and financiers, as well as uncertainty for subscribers. We also note that there is currently not a means or desire to require subscriber organizations to obtain a qualifying list of customers prior to energizing the facility, as enrollment is inherently a dynamic process. Turning now to the administrative fee, All four utilities have proposed the statutory maximum 1% administrative fee assessed on bill credit values to recover transactions and billing costs. This is what is to be used with net crediting. In Order 91-524, the Commission stated that it preferred to decide on specific cost components when more information was available on utility implementation and uncollectible costs. The Commission directed that utilities should be prepared to present a supporting record on costs when they file these tariffs. In spite of this, recent data responses provided by BG&E, Pepco, and Delmarva indicate that while the development of these consolidated billing systems involves millions of dollars of capital investment and hundreds of thousands of dollars in annual O&M expense, utilities have not requested a higher fee. Based on staff's preliminary analysis, the proposed 1% transaction fee is mathematically insufficient to cover these identified implementation costs. Because the electric companies have forborne the opportunity to request a higher evidence-based fee as permitted under your previous order, they have indicated they will default to recovering these program-specific costs through base distribution rates, decoupling charges, and SOS charges. Effectively, this shifts the burden of these commercial billing system services from the subscriber organizations to the general ratepayer base. Staff has carefully reviewed the formal requests from the joint solar parties, the Office of People's Counsel, and the individual developers. We agree that with these parties that Potomac Edison's unilateral discontinuance language should be rejected at this time. An outcome this severe should be standardized through formal commission regulations with administrative due process, not through individual tariffs. We also agree that standard tariffs for BG&E, Pepco, and Delmarva Power should be adopted without delay. Staff finds significant value in continuing this discussion to reconcile the legislative directives regarding LMI mandates and credit banking. Technical staff recommends that the Commission accept the tariff pages for Pepco and Delmarva effective January 1, 2026, and for BG&E effective February 1, 2026, per their previously granted waiver. We further recommend that the Commission conditionally accept Potomac Edison's tariff effective January 1, 2026, but exclude the language granting the company authority to discontinue for LMI shortfalls. Finally, we recommend directing the net metering working group to prioritize drafting regulations that reconcile the 1% fee revenue shortfall and the LMI compliance framework for inclusion in the upcoming Phase 3 rulemaking. Thank you, and I'm happy to answer any questions the Commission may have.
Okay, so any questions for staff on Delmarva, Pepco, and BG&E?
Pepco.
Anybody? No. Okay. You are?
No.
Just those three?
No.
Okay.
Yeah.
So, do you have comments on any of those three, or do you just want to talk about Potomac Edison?
No. I actually wanted to ask about the other three,
Oh, okay.
which kind of relates to Potomac Edison. So for the three Exelon utilities, for LMI shortfall, how is it? What's your understanding of how the utilities are going to address that issue?
Commissioner Suchman, I don't believe that we're going to do anything other than banking, although this matter came up very late in our process for the purpose of identifying this language with PE, because it was sort of introduced when we finally saw the PE draft. There's the language in the Exelon company's tariffs do not address this specifically. That doesn't prevent them from taking action, but it doesn't give them authority in the tariff to do it. So I would imagine when that issue comes up, they'll bring that to our attention. But there's nothing specific that says they're going to do anything about it right now.
Okay, and that's an issue that can be addressed in the working group.
But we hope so, yes.
Okay, all right, thank you.
Okay, so do you have any comments on either on the Exelon company's applications?
No, Your Honor.
So just on PE, right?
Yes, Your Honor.
Okay, so let me flip to Mr. Bugelman's.
Thank you, Chair Hoover, Commissioners. David Bugelmans on behalf of CCSA. Our only comments on the tariffs filed by the utilities other than Potomac Edison is we request that the Commission approve them today. We do have some broader policy recommendations that could apply to all four utilities, but I can reserve that for when we cover Potomac Edison, if that's
Okay,
appropriate.
sounds good.
And this is my client, so.
Oh, okay, all right. So he didn't want to say anything separate. So, all right. So let me deal with Delmarva, Pepco, and BG&E. So regarding item 4, I move we accept the tariff revisions for filing with an effective date of January 1, 2026. Commissioner McLean. Commissioner Linton.
Sir, before we vote, did Mr. Bugelman's, he said he had some broader policies.
Right, but I think he's going to incorporate those comments when he talks about Potomac Edison.
Okay.
And
Yeah.
our recommendations could work even if you approve the
Yeah.
tariffs.
Okay, just want to make sure.
That was
Sure,
gonna be
sure.
my question.
Okay, all right.
Okay. Aye.
All right, so we're all on the same, okay, so Commissioner McLean.
Aye.
This is to accept the tariff provisions for filing with an effective date of January 1, 2026 for item 4 Delmarva.
Still aye.
Okay, Commissioner Linton,
Aye.
Commissioner Suchman,
Aye.
Commissioner Barve.
Aye.
I vote aye. Item 5, I move we accept the tariff provisions for filing with an effective date of January 1, 2026. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barve.
Aye.
I vote aye. Item 24, I move we accept the tariff provisions for filing with an effective date of February 1, 2026. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barve.
Aye.
I vote aye. Okay, so any questions for staff on item 6, Potomac Edison? Commissioner McLean.
Good morning, sir. If things get referred to the working group, do you think you have sufficient time to sufficiently address those issues? PE referenced an April 1st, 2026 deadline. Does that give you enough time?
Yes, sir.
Very good. All right. Thank you, sir.
Anybody else? Okay, so let me go with Office of People's Counsel.
Good morning, Chair Hoover and Commissioners. Brock Miller on behalf of the Office of People's Counsel. OPC filed a short letter opposing PE's tariff language about disconnecting solar projects from the Community Solar Program when they fall below the 40% LMI requirement. I won't repeat staff's recitation of the background and facts, but I would like to reiterate that if a project is removed from the program, subscribed customers will also lose their bill credits and be dropped from the program. Additionally, OPC appreciated PE's filing yesterday evening, which clarified some of the company's thoughts that weren't maybe included in the original filing, including the Commission's role in any decision to remove a project, which was appreciated. A final point of clarification, though OPC mentioned the joint solar proposal to read the LMI requirement in conjunction with the new credit banking, in its letter, we only included it to highlight, to give a highlight that the work group participants have started discussing this issue. A footnote in PE's filing from yesterday appeared to construe OPC's mentioning of that proposal as some sort of endorsement. I just wanted to clarify that OPC is not at this time endorsing that proposal. OPC, like staff, recommends that the issue be further discussed by the work group and have the work group provide recommendations to the Commission, perhaps in the April 1st deadline for the rulemaking.
Okay, any questions for OPC? Seeing none, all right.
Thank you, Chair Hoover, Commissioners. David Bugelmans again on behalf of CCSA. We have very specific and urgent concerns with respect to Potomac Edison's proposed enforcement language related to LMI participation, and I'm hoping my comments will provide further context behind that. As a starting point, CCSA strongly supports the statutory requirement that community solar projects serve 40% LMI customers. Meaningful LMI participation is central to the program's equity objectives, and we're not asking to weaken that requirement in any way. But Potomac Edison's mechanism, which is in the tariff language before you, is both beyond what the law authorizes and would have catastrophic consequences for the program and Potomac Edison's service territory. Potomac Edison's proposed tariff language would allow the company to immediately remove projects from the program if a project does not, quote, maintain the 40% subscription level in any given billing period. In practice, based off the language that the utility has proposed, that would give Potomac Edison unilateral authority to remove a project from the program based on routine, temporary month-to-month fluctuations that occur due to customer attrition. And this is very common for projects. We have a 40% requirement. A project could be at the 40% level at the beginning of a billing period. A low-income customer could move, they could terminate their contract, and then for a portion of that billing period, drop to 39%. That happens all the time, given that we have a 40% requirement and nothing more. So, again, very common for projects to drop below that 40% threshold. The project, in this instance, in this example, would not have notice of this occurrence due to the timing of the utility subscriber reports, but Potomac Edison's language would allow the utility to terminate the project and drop all subscribers without any notice or warning. So what Potomac Edison has asked is for the commission to approve tariff language that would give it the ability to terminate operational projects without notice. There would be no commission involvement, no due process, no opportunity to cure, all before millions of dollars of investment are wiped away. And the consequences of that approach would be severe and immediate. Removal from the program would eliminate a project's revenue stream overnight, thus leading to stranded assets. And customers, again, many of whom, at least 40% are LMI, will lose bill credits and associated savings, essentially a form of reverse slamming where they return to their default rates. And from a market standpoint, the tariff language that Potomac Edison has proposed, which I know that they have submitted late yesterday qualifying language that's not in their tariff, but what's proposed, it creates this risk, right? So from a financing standpoint, it would make projects unfinanceable. So our concern is that if the commission were to approve this language, it would effectively bring the entire program to a halt in Potomac Edison for all projects moving forward. Importantly, as already has been mentioned, the program does include a mechanism that at least partially addresses this shortfall concern in a workable way. The statute, thanks to legislation passed this year, now includes a credit banking mechanism that, as of July 1st, allows unsubscribed energy to be banked for a 12-month period before it's paid out at avoided cost by the utility. Potomac Edison's proposal assumes that every component of a project's output must be assigned to LMI customers in a given month, at least 40%. But that assumption doesn't reflect the framework that the General Assembly has put into place. I would note that the credit banking mechanism also creates a strong economic incentive for developers to allocate credits generated within 12 months for being paid out at avoided cost. And that's because the value of avoided cost is significantly less than the credit value if they're allocated to LMI customers before the 12-month period. So there's already a strong economic incentive that's just a rational thing for project owners to do to allocate this generation. As I said earlier, Potomac Edison did file responsive comments after close of business yesterday. Those comments include some responses to discovery from staff, indicating it actually does not intend, or it does intend to provide notice to the commission prior to disconnection, and also apply additional rules to projects. None of these concepts are in the tariffs before the commission today, and it's concerning the utility was planning to apply these rules without including them within the tariffs. Again, what we have to think about is what has the utility proposed and what would the commission approve, and that language in and of itself, with the risk it would create, would bring the program to a halt in the Potomac Edison service territory. To summarize, CCSA requests 3 actions from the commission today. First, we request the commission approve these tariffs, including Potomac Edison, but reject Potomac Edison's draconian provision related to enforcement. So Potomac Edison would simply file a revised tariff with those provisions removed. Second, CCSA requests that the commission provide near-term clarity on LMI compliance by confirming that any LMI shortfall is treated as banked unsubscribed energy within the 12-month banking period until allocated to an LMI subscriber. And we've included specific language on page 5 of our comments that the commission could order the utilities to include in revised tariffs that be filed as a follow-on second tariff filing after approval today. And then third, to deal with the issue of LMI compliance after the end of the 12-month banking period, we respectfully request that the commission direct the net metering work group to develop a comprehensive solution for persistent LMI shortfalls after the 12-month banking period. And we did provide in our comments some examples of concepts that have been discussed within the work group that could eventually make their way back to the commission. And then those recommendations would make their way into the revised regulations or additional proposed regulations due by spring of next year. That concludes my comments. I'm going to hand this briefly to Mr. Kogashal to finish our remarks.
Thank you, David. Thank you, Chair Hoover and Commissioners. My name is Charlie Kogashal. I'm the Mid-Atlantic Regional Director for Coalition for Community Solar Access. David said it well, and I'll just kind of reinforce a few points. Potomac Edison's proposal creates an enormous risk for project financing, and I'll add that it also potentially pulls the rug out from participating customers if a project were to suddenly cease operation. And 2, in turn, create a new issue in Maryland associated with stranded projects, as OPC points out. There is a scenario here where 99% of the project capacity is subscribed and receiving energy cost savings, but because that 1% of unsubscribed generation is for the LMI portion, the entire project is cut off. Recognizing the evidence against it in this matter, Potomac Edison provided comments last night with a few minor new parameters, suggesting they'd only discontinue a project if it was short of the 40% LMI participation for 3 consecutive months. But this rebuttal by Potomac Edison would still create unreasonable risk. Indeed, the 99% scenario I just mentioned could still occur. Importantly, we do not contend that the legislature's intent was that every project have 40% LMI participation. We advocated for this as a key component of HB 908 during the 2023 session, and we are continuing to embrace it today as a core element of the community solar program in Maryland. We are also not looking to create a loophole. However, treating a shortfall in LMI participation as unsubscribed generation, inclusive of the 12-month banking ability established through the legislation in 2025, is a reasonable foundational policy requirement that results in a financial incentive to the project to maintain LMI participation and a consequential financial penalty for projects that are still short after 12 months. Indeed, it's the LMI participation and the slower acquisition and higher potential for turnover of these customers that the banking of credits for 12 months is most useful. A similar policy is in place in New Jersey, in large part because it too has a high LMI participation requirement. That said, as we state explicitly in our comments, we are also supportive of additional compliance process for projects that persistently fail to meet the 40% participation level in a material way, particularly beyond the 12-month grace period. Our interest to find common ground on additional compliance requirements is the reason Climate Access Fund signed on to our comments. Additional compliance could, among other things, take the form of increased discount savings being offered to subscribers to demonstrate a project's attempt to create a greater value proposition to customers. We welcome continued discussion with the Net Metering Working Group and believe we can produce a proposal to be included in the Phase 3 rulemaking in Q2 of next year. We hope the Commission will accept our recommendation today to establish the treatment of LMI as a LMI shortfall as first and foremost unsubscribed generation, and to task the Net Metering Working Group with developing additional compliance requirements to be established through regulation that extend beyond the unsubscribed generation treatment for projects that are persistently falling short of this important requirement. Thank you.
Okay, before I turn to questions, we had comments filed by a number of other solar developers. Are any of them present and want to say anything other than what we've heard from these folks? All right? Yeah. All right.
Honorable Chair Hoover, equally honorable members of the Commission. First of all, happy holidays, everybody. Appreciate it. So my colleagues here covered a lot very well. I'm just going to
Actually, I need to
sorry.
tell me who you are.
There you go. John Lennon Miller, Chaverton Energy. There you go. The proposed change by Potomac Edison disregards the past 8 years for precedent about how unsubscribed energy is treated. Plainly, there is no need to change course at the moment, especially when local energy generation is sorely needed, considering the impacts of PJM capacity constraints, as well as the work of the Commission in PC 73 to lessen administrative burdens to deploy local generation. The underwriting risk that this would introduce would just paralyze the solar industry at a moment where we really can't afford to have that happen. So I humbly request that the Commission strike the specific language as proposed by Potomac Edison. Thank you.
Okay. Anybody else? All right, seeing none, let me turn to questions. Commissioner Schlesman?
Okay, so Mr. Bugelbens,
Yes.
Yeah.
I can't see you, so you can see me, and this is
That's right.
the benefits and the challenges of being remote. So PE has provided a path for discontinuing service. Is there anything within the tariff that addresses how the challenges can be cured and for the project to get back into the utility's good graces?
There is not, Commissioner. As Mr. Kogashal said, we have concerns with this qualifying language that Potomac Edison's proposed late yesterday after close of business. But the key thing to remember is this language is not in the tariffs before the Commission. What Potomac Edison's proposed is basically one sentence that says, basically it creates the potential for this catastrophic scenario that we're warning about where a project could be removed without notice. That's That's the risk that would be created if the commission were to move forward today with that language, and there's no qualifying language about curing or anything like that before you.
Okay, and then this new statutory language that deals with unsubscribed energy. Is it your sense that that was the General Assembly's attempt to address shortfall issues?
It absolutely, I think, partially was. Both with LMI, but just subscription credits generally. The way that it worked before credit banking was if generation was unallocated in a billing period, it would just be immediately paid out at avoided cost. So from a customer perspective, those credits would not be available to then allocate and then provide those bill savings in later months. So it does create a mechanism where effectively those credits remain and they can be allocated. And then to the extent that generation is associated with the 40% that should have been to LMI or needs to go to LMI overall, that can be allocated in a later billing period. So it definitely accommodates that.
Okay, so if we were to accept PE's tariff language, would that serve to undermine this new unsubscribed energy provision?
It would, because it doesn't account for the fact that there's credit banking. What Potomac Edison has proposed, again, it's basically at all times you need to have 40% assigned to LMI customers. So if there's a drop, even briefly below 40%, that wouldn't be banked, and immediately the project could be disconnected. And again, I know they've proposed qualifying language, but that's, a quote from a data request response. It's not in the tariffs that are before you.
Okay. Well, Mr. Chairman, unless I hear something differently that can change my mind from Potomac Edison, it seems to me that their proposal is rather draconian, doesn't allow for any ability to cure, and seems to undermine this new statutory language that the General Assembly enacted in 2025. That's all I have.
Okay. Any other questions? So, Commissioner Suchman asked you about whether or not the company had proposed a reinstatement process, but I mean, how would that work if we gave them this authority? I mean, what are the practical aspects of, say you got cut off because you fell below the 40%, what would have to happen in order for you to get reinstated?
It's a can of worms. It's something that the industry, it's not seriously something the industry would entertain if we were to discuss that in the work group. Because what you're talking about is you're taking, multi-million-dollar asset and then just, overnight, it's like basically worthless, right? So, there could conceivably be some kind of process to bring it back online, but we just think that concept, except in maybe extreme circumstances of extreme noncompliance and recklessness, is just beyond draconian. So that's why we've focused on in the work group processes to basically to sort of enhance credit value, to do various things to try to bring projects back into compliance, and then obviously a component of that would be the Commission's enforcement authority, through a proceeding if there is like an instance of major noncompliance. But the idea of disconnecting a project and bringing it back online, that is the fundamental concern that we have.
Okay. All right, let me turn to Potomac Edison.
Good morning, Chair and Commissioners. Jessica Reba on behalf of Potomac Edison. Happy holidays. We come bearing the gift of controversial tariff language for you. First, I want to thank staff and stress that, as Mr. Vanderheiden said, that the main purpose for our tariff revisions today is to implement consolidated billing. Potomac Edison is ready to do that on January 1 as required by the law. Our team has worked really hard to meet that deadline, so I don't want to take away from that, and I think that really reflects our commitment to this program and to our collaboration overall in the net metering working group. That said, you've obviously heard that our additional provision around enforcing the statutory requirement of a 40% LMI subscription has caused a little bit of controversy. we did file comments last night that reflected discovery responses we gave to staff, hoping to clarify that this was not intended to be the catastrophic outcome that the industry seems to think it would be. We would expect there absolutely to be a cure period. We would expect notice. We would expect to make a filing with the commission before we took any action. That said, we know that's not in the tariff language specifically. We would be happy to amend the language to include that. Alternatively, if you think it's worth sending this back to the work group for further discussions to try to implement something through regulations, we are amenable to having those discussions. But we would ask that the commission do two things. One is set the deadline of April 1st for those regulations, and two is to provide hopefully a little bit of guidance in terms of your view of interpretation and implementation of the law. You've heard there's sort of a fundamental disconnect, I think, between at least Potomac Edison and the industry on whether this credit banking can apply to the LMI subscription and for how long and what happens at the end of that 12-month period. So, I would hate for us to be back here 4 months in exactly the same position, because I'm not sure that any number of working group meetings is going to have us and the industry agree on that point. So that said, we're happy to answer any questions you might have on our position. But I don't want to belabor the point if, that's the direction that we're going.
Okay, questions for the company? Commissioner Linton.
Yeah, thank you, Mr. Chairman. Good morning. So, Merry Christmas, first of all, to you as well. Happy holidays. Help me to understand what the company's rationale was for proposing the enforcement mechanism as part of your tariff language. I mean, I'm just trying to understand what the rationale was for doing that.
Sure, absolutely. So it actually originated in the working group because there was a proposal from some of the developers to put language in our tariff that would allow for the LMI shortfall to be counted as unsubscribed energy, as you heard them describe. We, Potomac Edison, does not believe that that complies with the intent of the law, and we're uncomfortable putting that in our tariff. It also made us recognize that as, the entity that is making these payments to developers, there is no sort of enforcement mechanism around this 40% requirement, right? So is it our responsibility, if no one else is doing it, to make sure that the project qualifies as a community solar project by meeting that 40% requirement, and are we in the right to be funding it that way, basically? So we think it's a really important requirement. We think the law is clear that it is a requirement of qualifying as a project. So there's nothing in the statute or the current regulations that enforce that requirement. So we thought at least to get it in front of you as an issue through our tariff was the way to go.
Okay, so it sounds like you were thinking that you would just get it in front of us, as you suggested, as opposed to this being language that you were entirely focused on proceeding on.
That's fair. Yeah, we are amenable to going back to the working group, but we're hoping to get, like I said, a little bit of policy direction.
Okay, so I appreciate that that the company is prepared to move forward on January 1st with consolidated billing. Have any of the solutions that you included in your tariff, are those built into the consolidated billing mechanisms you have behind the scenes?
No. You could, right. So we would envision that if you elect not to adopt this one provision, we would simply make a clean compliance filing that removes that one sentence. Everything else would stand as is and not be implicated by that.
Okay, so with that language removed, then you'd still be able to move forward on January 1st?
Absolutely.
Okay. All right, that's all I have. Thank you, Mr. Chairman.
Commissioner Barbie.
I think I've heard everything I need to hear. Thank you.
Mr. McGlynn?
Good morning, ma'am. The April 1st, 2026 deadline for regulations, so is that the deadline to issue the regulations?
I believe that's the deadline the work group has for
Okay.
proposing them, but Mr. Vanderheden
Okay.
can probably correct me.
Well, that would just cut into your work group time, in theory.
Right. It would involve prioritizing
Right.
this over other issues that we're
Right.
tasked
All
with
right.
drafting regularly. Yep.
I was trying to get time-wise. Thank
Yep.
you.
Commissioner Slichman?
Yeah, so to follow up on Commissioner Linton's line of questioning, in terms of sort of the motivation of this provision, have you encountered issues around community solar projects not meeting their 40% threshold?
Yeah. So we haven't been tracking it, is the short answer, to date. I think we are in the process of developing our system so that it will be able to do that based on information that will be submitted to us by the subscriber organizations. So they will be submitting to us information about the subscribers and whether they are LMI, and our system will be set up to tell us, oh, this is 39%, this is 42%. But to date, we haven't been tracking it.
Okay, so at this point, you don't know that you have a problem.
That's fair, sure.
Okay, so you're asking us to approve language to address an issue that may not be a problem.
I mean, I would proffer that I think the fact that the developers are trying to proactively get us to treat the shortfall as unsubscribed energy suggests to me that they may anticipate there's a problem, but that's my speculation.
Right, but we don't have their proposal before us. We only have
You do. It's in CCSA's filing. They provided their drafting tariff language.
And you're aware that none of the other utilities are asking for this language or anything like this language.
I am aware.
Okay, so is it that they don't perceive that this is an issue, or is there something that's unique to the PE service territory that would make this an issue for you and not for them?
I don't think there's anything unique to PE on this issue, but I can't answer for them as to why they aren't proposing language.
Okay. Well, Mr. Chair, I'm not sure that Ms. Reba has changed my mind about this, and given that there doesn't seem to be a problem that needs to be fixed, but that this language could actually create very big problems for the community solar industry. I think we need to strike the language, and if the working group needs to find a path forward, we should let them do it.
Okay.
That's all I have.
Okay, thanks. So there's been this question that we asked of the solar developers. I mean, if you had this authority and if you took this action, what would be the process for the solar developer to get back into the program?
I think it's as simple as providing us a subscriber list that meets the 40% requirement.
But I mean, how quick? I mean, I guess what I'm concerned about, they laid out a number of things that would happen, particularly to the customers, who would no longer be getting that credit. I mean, what would be the practical aspects of trying to reinstate that credit? And are we, going to have a whole lot of filings and delays as you're, going through verifying, that they've resubmitted the right numbers?
To be frank, I'm not convinced it's quite as complicated as they're making it sound. I don't.
Well, I guess based on what I've read, it does strike to me that it's pretty complicated.
I don't see how it's any different than a new project coming online. I guess I don't.
Okay. All right. So let me turn back to staff, and you can react to what you heard from both the solar folks and PE. But one question I have is, there's been this discussion that this idea was brought before the working group. I guess I'd like some discussion about what was, proposed, what was considered, and I guess this other question about, was this just PE's idea and they alone were the only ones pushing it, or somebody else wanted to do it too?
Certainly, Mr. Chair. The issue about banking came around in the working group after that particular law went into effect in July. So we basically had to make sure the utilities were able to perform the banking. So unsubscribed energy can happen, I think, on startup most commonly, and I think in the other states where they've implemented similar law. Before you get a project up and running, it's not always possible to get a full customer list, so that takes a little bit of time. So often, one of these things is energized, and the customer list isn't ready, so they, rather than simply lose the full retail value and just get paid out as basically LMP prices, that law was passed, and that was created in Maryland, not only for startup, but at any point in time, the way it's written, and I think the way it was, we discussed it, if they drop below a full customer list, they're able to bank it. So it's a nice feature. The issue about what happens if you don't hit the 40% target came up probably a few months later, probably in like October or November when we saw the final tariff language. So I think PE made a good case for saying, hey, this is the definition of what a CGIS is. It's got to have 40%. If it's no longer providing 40% or never did, how can we comply with the rest of the law? So I mean, they made a fair point there, but then the solar folks were like, hey, well, we have banking now, so that should solve this issue. And then the issue came up as well. Okay, well, does that create a reverse incentive where you can just follow along with that for a while and not actually try to reach out and serve the 40%? So that's how it sort of went back and forth on that. At the time, we didn't really have a lot of working group time to, before we had to get this issue in front of the commission to get it done by the end of the year. So it was suggested that this get tabled and dealt with in regulations, and there were a couple attempts to sort of come up with another mechanism, but it never really reached something that had been fully vetted. And with the time constraints as we approached December and the end of the year, we never fully were able to resolve it. It seems like something that should be uniform across all the service territories, which to me says regulations is the best way to work it out, get the policy, in place, and then all the utilities can draft a tariff that do this and do it in a way that's consistent. So that was staff's recommendations, but we also recognize, PE had a point. It's like, hey, the way we're reading the law, if we don't do something like this, we'll be potentially violating it if there's a project that drops out. So it's understood, I think, that the reason the banking legislation was part of that is because it's known that's something that happens routinely on startup for projects. So really the best move forward in our view would be to think about how to do this and reconcile these two different pieces of the law so that we, I think that's what regulations are very good at doing, and doing so in a consistent manner. So that's what we try to get folks to agree to, but I think there was a need to get a commission policy read on this from the folks that were proposing it, and then clearly the solar industry has reacted to this in a manner that shows that's very important to them. I guess because they are very concerned about a project's coming offline without warning. Although I got the impression that PE understood that and was not planning to act in such a draconian manner, but the tariff language would have allowed them to do it, so there's the reaction.
Okay, so question for the company, a practical question. If we decide to not grant you this authority, do you need to refile the proposed tariffs?
I think you could approve our tariff without that language, and then we would just make a compliance filing with a clean tariff page that reflects that approval.
That work for you?
We should probably identify. We haven't talked about what the language is. I hope everybody understands. It's one line.
No, I understand. Yeah,
Okay, you have that?
Got,
Okay.
yeah. So we can make provisions for that, but
We're
I'm just
we're
wondering.
recommending simply accept the tariff for filing without that sentence.
All right, so I'm going to propose. Wait a minute.
Okay, I promise. Okay. Mr. Bugelman's pointed out that it is in 2 places, but I promise we will take it out of
Oh,
both.
I understand. Okay. All right. So I want to do this. I'm going to propose that we approve the tariff language without this authority for them to eliminate a project from the program. But I want to do a separate letter order or direction to staff regarding what the working group should be considering based on some of the discussions we heard from the solar industry. So that'll be a separate written thing that we'll issue at a later point. So with that, I move we accept the proposed tariff pages for filing with an effective date of January 1, 2026, excluding the tariff language on granting the company authority to discontinue service to projects that do not maintain a 40% kilowatt output to the LMI requirement. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barbat.
Aye.
I vote aye.
Thank you.
Items 7 and 8 are tariff revisions from Potomac Electric Power Company and Delmarva Power and Light Company.
Good morning, Chair and Commissioners. David Hopbuck on behalf of staff. On December 2nd, 2025, Pepco and Delmarva filed revisions to their electric supplier coordination tariffs to discontinue UCB, Utility Consolidated Billing, for residential retail choice effective January 1, 2026. As background, on October 9th, 2025, the joint utilities, including Pepco and Delmarva, filed their plan for no longer providing residential UCB as of January 1, 2026, consistent with Order 91463, which implemented the Senate Bill 1 prohibition on residential retail choice, POR. Additionally, the joint utilities stated their willingness to drop a residential choice customer to default service if a supplier fails to drop the customer or switch the customer to dual billing. Staff filed its response to the joint utilities on November 26, 2025. In its response, staff recommended that the Commission issue an order allowing utilities to drop a residential retail choice customer to default service if the customer supplier takes no action. Pepco and, in a December 4th, 2025 filing, OPC supported this recommendation. Pepco and Delmarva proposed changes to their electric supplier coordination tariffs that state that they may remove a customer from retail supply if provided by a Commission order or required by law. This facilitates Pepco and Delmarva dropping a customer whose supplier takes no action if the Commission accepts staff's recommendation. Staff worked with Pepco and Delmarva on tariff changes which state that residential UCB is no longer available after December 31, 2025, while allowing for cancel rebills and 2026 billing that includes 2025 residential retail choice usage. Staff recommends that the Commission accept the proposed tariff revisions as revised by staff with an effective date of January 1, 2026, and require Pepco and Delmarva to file clean copy tariffs. Staff is available for questions.
Okay, so Commissioner Suchman, I actually can't see you on the screen, so if you have a question, go ahead.
I don't have a question, but I can see myself.
Okay.
So I don't know what's going on.
No, it's just that.
But I won't, Chair, I won't take it personally.
No, that's fine. It's just the size of the screen thing. Commissioner McLean, Commissioner Barbat, Commissioner Linton, go ahead.
Yeah, thank you, Mr. Chairman. Good morning. Just one question for staff. I didn't see that there were any comments from anyone in the competitive supplier industry. Did we receive anything at all?
Go ahead, Dave.
Yeah, I figured I'd ask you.
Yeah, not on the tariff filings. You're correct, Commissioner Lynn.
Okay. All right. Thank you. That's all I had.
So,
Oh, wait. I'm sorry. I didn't see you over
so
there.
do you have a comment? All right, go right ahead.
All right.
Yeah, good morning, Chairman Commissioners. Eric Wallace with the law firm Green Herlocker on behalf of the Supplier Coalition. These issues around implementation of SB1 have a long history, and the Supplier Coalition did file a letter on December 12th. There's been a series of, I believe, 7 filings now from the Supplier Coalition, including a motion to stay, a renewed motion to stay, and a second renewed motion to stay. The concern from the Supplier Coalition is not about any of the specific mechanics in the utility filings, and these comments really address matters 7 through 12 on the administrative meeting agenda this morning, so I'm just going to say this once, and then it will generally apply to all those matters. But what the Supplier Coalition is seeking is an opportunity for a seamless transition from the UCB with POR structure that we had prior to SB1 through to a utility consolidated billing framework that's available without POR. And in last year's order, the Commission decided to end UCB with POR effective January 1st. We don't have a alternative available heading into 2026, and so the Supplier Coalition remains very concerned about the effect that will have on their ability to offer products that comply with SB1 moving forward. And so, I just wanted to highlight those comments, that position. Again, nothing specific on these tariff requirements, but to the extent that the Commission is open to engaging, directing the parties to work towards or reinitiate the process of developing a UCB framework without POR, the Supplier Coalition remains interested in that, but things have kind of stalled out this year, and so I wanted to briefly offer those remarks, and then I'm happy to answer any questions the Commission may have.
Mr. Linton.
Yeah, thank you, Mr. Chairman. So the question I was going to ask, I was hoping a supplier would be here to answer, was could you tell me what the current state of the supplier activity is now in Maryland? Are some of your companies still marketing, or are there's any? What are you doing?
Yeah, so it's wound down. I believe I don't know if there are any residential customers that are still shopping. We were approaching that, and I know that the suppliers that I've heard from have been submitting their drops for the remaining customers. There may be a few that remain. The challenge is, when UCB goes away, there's no viable billing alternative. Suppliers, dual billing was really the only thing left, right? And that's not a viable alternative for suppliers to make offers in this market. Customers don't like it. Suppliers have to build out the processes to do that, and there remains a lot of challenges around, the SB1 construct in general that limit the ability to make offers. So I think if, so the bottom line is, the shopping enrollment numbers have dropped precipitously throughout the year. We're approaching zero. I don't know if we're quite there yet.
Okay, so there are no suppliers that either are planning to or who currently do offer dual billing or any solution similar to that?
For residential customers, not that I'm aware of. There was one supplier who had some kind of a hybrid product. Deca Energy had some filings around that in the course of this process. I'm not sure where they are, but I haven't heard among the Supplier Coalition of anybody that has developed a dual billing, operational billing structure for SB1 offers that would be able to move forward.
Okay, thank you.
Mm-hmm.
Thank you, Mr.
Any questions, Commissioner Schlesman? Any questions? Okay. All right. Let me turn to Pepco.
Good morning, Chairman and Commissioners. Happy holidays. Taylor Beckham here on behalf of Potomac Electric Power Company and Delmarva Power and Light Company. The company appreciates staff's review of our filing, and we are fine to make the changes that staff has proposed, and would otherwise ask that the Commission approve the filing. Thank you.
Any questions for Pepco? Alrighty. Okay. With that, I move that we, on item 7, move it.
Mr. Chair, I think, Ms. Herman, did you have something?
Yes, Ruthie Herman on behalf of staff. I just wanted to reply that just to remind for the record that the Commission did not say that there can't be any UCB. In the Commission's order number 91463 issued December 30th of 2024, it said that the utilities are no longer required to offer a UCB format. And then second, it would be that staff is always willing to work with the stakeholders to see if there are any viable and cost-effective POR alternatives, some other kind of UCB. And then the last thing we wanted to say is we have seen some dual billing. I believe that Mr. Hoppick has something in the queue that's asking for how we can collect that data. And I believe that's still before the commission for consideration. But anecdotally, we have seen some residential customers dual billed. Thank you.
Okay. All right. So with that, regarding item 7, I move we accept the proposed tariff language as revised by staff and its comments dated December 17, 2025, with an effective date of January 1, 2026. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Mr. Barbie.
Aye.
I vote aye. Item 8, I move we accept the proposed tariff language as revised by staff and its comments dated December 17, 2025, with an effective date of January 1, 2026. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barbie.
Aye.
I vote aye.
Item number 9 consists of additional tariff revisions from Southern Maryland Electric Cooperative, Inc.
Good morning again, David Hoppick on behalf of staff. On December 2nd, 2025, SMECO filed revisions to its electric supplier coordination tariff to discontinue UCB for residential retail choice effective January 1, 2026. SMECO proposed changes to its electric supplier coordination tariffs that state it may remove a customer from retail supply if provided by a commission order or required by law, or if the supplier enrolls a customer with a billing service option that is not allowed per the tariff. This facilitates SMECO dropping a customer whose supplier takes no action if the commission accepts staff's recommendation. Other edits, as revised by staff, state that residential POR and UCB are no longer available after December 31, 2025, while allowing for cancel rebills and 2026 billing that includes 2025 residential retail choice usage. This language is consistent with the language agreed upon by staff and the Exelon utilities. Staff recommends the commission accept the proposed tariff revisions as revised by staff with an effective date of January 1, 2026, and requires SMECO to file a clean copy. Again, staff is available for questions.
Okay, any questions? All right, seeing none, I move we accept the proposed tariff language as revised by staff.
Do you want?
Oh, actually, I mean, I assumed you didn't have any.
Oh.
I'll just introduce myself, but certainly I have nothing further to offer. Damon Krieger, good morning, happy holidays on behalf of Southern Maryland Electric Cooperative. Thanks to Mr. Hoppick, who did a wonderful job coordinating all of the tariffs to ensure consistency across the utilities, and we are comfortable with the proposed changes from staff to our proposed language. Nothing more unless you have any questions. Thank you.
All right, thank you. So with that, I move we accept the proposed tariff language as revised by staff and its comments dated December 17, 2025, with an effective date of January 1, 2026, and direct the company to file clean copies of its tariff pages. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barbie.
Aye.
I vote aye.
Item number 10 consists of more revisions from the Baltimore Gas and Electric Company.
Good morning, Chair and Commissioners. Brandon Bowser on behalf of staff. On December 2nd, 2025, BGE filed revisions to their electric supplier coordination tariff and gas supplier tariff to discontinue UCB, utility consolidated billing, for residential retail choice effective January 1, 2026, per the background on the Joint Utilities October 9 filing provided by Mr. Hoppick in his prior comments. BGE proposed changes to their electric and gas supplier tariffs, which state that they may remove a customer from retail supply if provided by a commission order or required by law. This facilitates BGE dropping a customer whose supplier takes no action if the commission accepts staff's recommendation. Staff worked with BGE on the tariff changes, stating that residential UCB is no longer available after December 31st, 2025, while allowing for cancel rebills and 2026 billing that includes 2025 residential retail choice usage. Staff recommends that the Commission accept the proposed tariff revisions as revised by staff with an effective date of January 1st, 2026, and require BGE to file a clean copy of each tariff. Thank you, and I'm available for questions.
Any questions? Seeing none.
Morning, Chair, Commissioners. Daniel Herson for BGE. Happy holidays. No disagreement with what Mr. Bowser says. The company worked with Mr. Hoppick and Mr. Bowser on the revised language. We have no objection to staff's recommended changes to the tariff language, and we will file a clean copy as directed.
Seeing no questions, I move we accept the proposed tariff language as revised by staff in its comments dated December 11, 2025, with an effective date of January 1, 2026, and direct the company to file clean copies of the tariff pages. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barbe.
Aye.
I vote aye.
Item number 11 consists of additional tariff revisions from Washington Gas Light Company.
Good morning, Chair and Commissioners. Evan Thomas on behalf of staff. On December 3rd, 2025, Washington Gas Light Company filed a revision to its supplier agreement rate schedule, which is WGL rate schedule number 8. WGL's proposed language states that it may remove a customer from retail supply if provided by a commission order or required by law. This facilitates WGL dropping a customer whose supplier takes no action if the Commission accepts staff's recommendation, as described by Mr. Hoppick in his comments for Pepco and Delmarva. WGL's tariff currently states that WGL will not purchase receivables for residential customers after December 31st, 2025. However, consistent with staff's approach with the other utilities, staff recommends adding clarifying language that allows for cancel rebills and 2026 billing that includes 2025 residential retail choice usage. Staff recommends that the Commission accept the proposed tariffs as revised by staff with an effective date of January 1st, 2026, and require WGL to file a clean copy. Thank you, and I'm available for any questions.
Any questions? Seeing none?
Spencer Nichols on behalf of Washington Gas. The company appreciates and agrees with staff's review and recommendation.
Okay.
I do have one for you.
Okay, go ahead.
Thank you, Mr. Chairman. Good morning. I do recall that Washington Gas did have a company that was offering a pilot form of dual billing. Could you give us an update on that? Or is it still happening, or I believe it was Deca Energy or something?
I'm sorry, Commissioner Lynn, I do not have an update on that, but I can certainly take that as a bench request if you prefer.
Okay. I just wanted to make sure that whatever, if the pilot's still going, or if the company is still offering service to customers, that whatever we're prepared to adopt today in the tariff doesn't interfere or cause some challenge for them. And again, I don't know what the status is of the pilots.
I can certainly represent that this tariff change will not interfere with any pending pilot that's occurring with that particular supplier.
Okay, and it could be beyond the pilot too. I don't know how involved it is, but I do know that they made quite an effort to move forward with dual billing for gas customers.
Understood, Commissioner.
All right, so Mr. Chairman, just with the understanding that if there's currently customers there that are engaged in some form of pilot or something, that this tariff language shouldn't be interpreted to interfere with that.
Okay.
Thank you.
So noted. All right, with that, I move we accept the proposed tariff language as revised by staff and its comments dated December 17, 2025, with an effective date of January 1, 2026, and direct the company to file clean copies of the tariff pages. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barbe.
Aye.
I vote aye.
Item number 12 consists of additional tariff revisions from the the Potomac Edison Company.
Good morning again, Chair and Commissioners. Brandon Bowser on behalf of staff once more. On December 2nd, 2025, Potomac Edison filed revisions to their electric supplier coordination tariff to discontinue utility consolidated billing for residential retail choice effective January 1, 2026, again, per the background on the October 9th filing provided by Mr. Hoppick in his prior comments. Potomac Edison has also proposed changes to its retail electric service tariff, similar in nature to those proposed for its supplier coordination tariff. Regarding its supplier tariff, Potomac Edison proposed tariff changes which state that PE may remove a customer from retail supply if provided by a commission order or required by law. This facilitates Potomac Edison dropping a customer whose supplier takes no action if the commission accepts staff's recommendation. Staff worked with Potomac Edison on tariff changes stating that residential UCB is no longer available after December 31st, 2025, while allowing for cancel rebills and 2026 billing that includes 2025 residential retail choice usage. Potomac Edison has also proposed changes to the definition section, which modified the definitions of standard offer service, or SOS, Type 1 SOS, and Type 2 SOS to remain consistent with the definitions in the company's retail electric service tariff. Staff supports these modifications to ensure the definitions are up to date. Potomac Edison further proposed to remove language pertaining to the availability of UCB for budget billing, which is available only to residential customers, and staff does not oppose these modifications. The company has further proposed to add language to Schedule 4 seamless moves pertaining to 814 move transactions. Staff opposes this addition as staff concludes that the modifications in Section 7.8, Customer Designation to Control, already effectuate this, and as such, the proposed 814M language would be duplicative and potentially confusing for customers. Regarding its retail electric service tariff, Potomac Edison has proposed modifications to Section 10, Metering and Billing, to effectuate the discontinuation of UCB for residential customers, similar to the modifications proposed to its supplier tariff. Staff worked with Potomac Edison on language that specifies only non-residential customers have the option to choose whether the company or the electricity supplier uses UCB, and to add clarity in language pertaining to the availability of supplier consolidated billing. The remainder of the company's proposed changes add clarity on the availability of the company's two-bill option for customers after December 31st, 2025, specify that residential customers can only receive separate bills from their supplier and the company, and state that the company no longer has an obligation to purchase a supplier's receivables for residential customers. Staff does not oppose these modifications. Staff therefore recommends that the Commission accept the proposed tariff revisions as revised by staff with an effective date of January 1st, 2026, and require Potomac Edison to file a clean copy of each tariff. Thank you, and I'm available for questions.
Any questions? Seeing none.
Good morning again, Jessica Reba on behalf of Potomac Edison. We also thank staff for the collaboration and have no objection to their changes and are prepared to file a clean tariff consistent with their recommendation.
Any questions for PE? All right, I move we accept the proposed tariff language as revised by staff in its comments dated December 13th, 2025, with an effective date of January 1, 2026, and direct the company to file clean copies of its tariff pages. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barbe.
Aye.
I vote aye.
And items 13 through 19 consist of Empower filings from the Potomac Edison Company, Washington Gas Light Company, Delmarva Power and Light Company, Potomac Electric Power Company, Baltimore Gas and Electric Company, and finally the Southern Maryland Electric Cooperative.
Good morning, Chair and Commissioners. Paige Shaw on behalf of staff. As the Executive Secretary said, items 13 through 19 represent filings from the Potomac Electric Power Company, Washington Gas Light Company, Delmarva Power and Light Company, Potomac Edison Company, Baltimore Gas and Electric Company, and Southern Maryland Electric Cooperative's proposed updates to their Empower Maryland surcharges for 2026. Staff has reviewed the filings and notes that the proposed costs in 2026 are very similar to the costs proposed in the company's 2024 to 2026 Empower Maryland program filings filed on August 15th, 2024. Additionally, BGE is requesting tariff language revisions to the new DR charge for small general service customers, as well as additional language revisions to Rider 15 and Rider 26 for changed participation requirements for those programs reflected in the company's revised 2024 to 2026 Empower Maryland program plan, as approved by Commission Order Number 91461. Staff recommends that the Commission accept for filing the company's proposed language revisions to Rider 2 Electric Efficiency Charge, Rider 15 Demand Response Service Charge, and Rider 26 Peak Time Rebate Charge effective with the exception to the change in tariff language for Rider 26. Staff recommends the Commission accept staff's proposed language for Rider 26 and direct the company to file clean copies for Rider 26 Peak Time Rebate Change. Finally, staff recommends the Commission accept for filing the proposed surcharges with the effective date stated in the company's tariffs. And with that, staff is available for questions. Thank you.
So, any questions for staff? Commissioner McLean.
Good morning, ma'am. It seems the PHI companies, their increases are pretty significant. Is there any, were you able to determine why their increases were so high?
It's due to the higher costs and the change in amortization is fully expensed this year, so hopefully all things stay the same. Next year, the surcharges should decrease.
Okay, for all the companies?
Yes.
Okay, thank you.
Anybody else? So, any of the companies have any?
I don't know if you can. Can you see
All right,
me?
go ahead. Yeah, actually, now I can see the hand. Go ahead.
Okay.
Sure.
So I just wanted to follow up a little bit on Commissioner McLean's questioning, because I'm looking at it, and if you could just give us a little bit more, a little sort of go down into the weeds a little bit more and explain the significant change, because we're not talking about a small change. I mean, for example, Delmarva bill impact represents a 59% change. And Pepco 50% change. So it's going up pretty significantly, and I'm not questioning the need to do this, but given that ratepayers are seeing increases in their bill from a number of different places, if you can just go into a little bit more detail about why we're seeing such a big change.
I will let Ms. Beckham dig a little deeper into that.
Okay, thank you.
Go ahead.
Good morning, Chairman and Commissioners. Taylor Beckham here on behalf of Potomac Electric Power Company and Delmarva Power and Light Company. The short answer is that the PHI utility surcharge is going up because we are fully transitioning to the expense method as directed by the Commission. That's what the numbers basically represent. If there's anything specific, I do have Kaja Dana here, one of our senior managers from the rates team, to go into it, but I think that's the long and short of it.
Okay, so the 59% increase that I'm looking at for Delmarva reflects the movement to expensing.
Yeah.
For this year, I'm assuming once we go to 2027, because you've already done your transition, we're not gonna see the big jump up in bill impact that we're seeing right now.
So the impact to the surcharge that you're seeing in 2026 is the movement to expense as well as project costs. Obviously, we don't know what 2027 will look like because that will be a new cycle and those project costs will be what they are once they're approved. But as far as the expensing method aspect of the expense or impact to the surcharge based off of the expense method, I think we can expect that wouldn't be something you see in 2027.
Okay, so I guess my question is, it's one thing to have this reflect a transition so that customers will understand. We're seeing a bit of a bump up, or not a bit. I mean, it's a big bump up when we're talking about 59%. But we're not expecting that to occur in the following year. I mean, I for example, am not going to be really happy if at the end of 2026 I'm looking at another 59% increase in impact. I mean, I'm looking, for example, at Delmarva, we're going from a $12.70 charge to $20.14. That's a big jump up. And if the reason is we're transitioning to an expense methodology, that's one thing. But but I was hoping you would say we're not going to have those kinds of impacts going into the following year because we're through this transition period.
The impacts that you're seeing to the surcharge right now are largely because of the transition to the expense method, but there's also the project costs. I don't think, and again, we can't say what the future project costs will be and the impact that that would have on the future surcharge, but to the extent that the expense method transition has been complete, we shouldn't see that additional add to the surcharge.
Okay, well, I can tell you, Ms. Beckham, that next year I'm going to expect our staff to give me 2025, 2026, and 2027 numbers for all the utilities to see whether that bump up is only because of a transition to expensing or something else. And that something else will cause me a little bit of heartburn.
Okay.
That's all I have.
Anybody else? So actually, but let me ask you a question before you respond. So obviously, as was alluded to by Commissioner Suchman, the elephant in the room is the decision that was made by both this commission and the General Assembly to deal with what's been referred to as the credit card debt related to Empower. And so a lot of this amount of these particular surcharge increases is attributable to the decision that was made to pay off that debt, correct?
Yes, I will say in the 2027 to 2029 program cycle plans, we review the costs and the surcharges for those years in those filings. So this is something staff will be reviewing when those plans come in, and we can review the increase in surcharge expected.
Okay, all right. So any other questions for staff? All right, so let me start with item 13. I move that we accept the tariff provisions for filing with an effective date of January 1, 2026. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barve.
Aye.
I vote aye. Item 14, I move we accept the tariff provisions for filing with an effective with the January 2026 billings. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barve.
Aye.
I vote aye. Item 15, I move we accept the tariff provisions for filing effective with the January 2026 billings. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barve.
Aye.
I vote aye. Item 16, I move we accept the tariff provisions for filing effective with the January 2026 billings. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barve.
Aye.
And regarding item 17, I move we accept the tariff provisions for filing effective with the January 2026 billings. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barve.
Aye.
I vote aye. And regarding item 19, I move we accept the tariff provisions for filing with an effective with the January 2026 billings. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barve.
Aye.
I vote aye. Regarding item 18, I move we accept for filing the company's proposed revisions to Rider 2, Electric Efficiency Charge, Rider 15, Demand Response Service Charge, and Rider 26, Peak Time Rebate Charge, effective with January 2026 bills, including the proposed changes to the language of the tariffs, with the exception of the change in tariff language for Rider 26, that we accept staff's proposed language for Rider 26 in its comments dated December 17, 2025, and direct the company to file clean copies for Rider 26 Peak Time Rebate Charge. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barve.
Aye.
I vote aye.
And
Actually, so at this point, we're just going to take a 10-minute break because we got relatively long agenda. So just hang close in the room. So we'll be back at 11:30. right, so if we could get back on the schedule again, Mr. Secretary.
Item number 20 is a public charging plan update from Baltimore Gas and Electric Company.
Good morning, Mr. Chair and Commissioners. Oladipo Fadei on behalf of staff. On December 11th, 2025, BGE filed its public charging network plan update. The filing presents a three-part plan to improve the cost effectiveness and reliability of its public charging network. BGE's first proposal is to decommission 35 DC fast chargers and replace 36 underperforming level 2 chargers in its network with Zorova AX series chargers. BGE's L2 only stations reported an average uptime of 90% in Q3 2025. Staff acknowledges the challenges that BGE faces with obtaining the parts necessary to maintain service at many of its level 2 chargers and supports its plan to replace the chargers at identified locations with uniform and reliable replacement chargers. Replacement of underperforming charging equipment seems like an effective strategy to ensure reliability across BGE's charging network. The second proposal seeks to remove and transition underperforming DC fast charging sites located at the BWI cell phone lot and the BWI rideshare lot. Staff deferred to the Maryland Department of Transportation on this matter in its filed comments, and the Department of Transportation responded, filing comments calling for the continued operation of these chargers through 2028. Acknowledging that the proposed transition timeline was unrealistic. Staff supports the company's plans to decommission every other DC fast charger identified in its plan. The third proposal would replace chargers at select sites with bring-your-own charging infrastructure to reduce maintenance costs associated with vandalism and theft. Some interveners have argued that bring-your-own charger would not solve any cost or reliability issues. And even though theft and vandalism do not appear to be major drivers of cost or downtime, staff values the opportunity to learn whether the ability to charge devices other than cars, with no restrictions on connector types, could be of value to charging customers. Staff recommends the Commission accept the rip and replace and bring your own charging components of BGE's charging plan, authorizing the company to replace identified level 2 chargers and allowing for additional funding to support the decommissioning of identified DC fast chargers. However, staff recommends the Commission deny the transition plan outlined in Part 2, and in accordance with the Maryland Department of Transportation's comments, prevent the immediate decommissioning of BWI chargers. Staff's open for comments.
Okay, any questions for staff? Commissioner McLean.
Good morning, sir. Why shouldn't we just make this a RIP instead of a rip and replace? Why is Mr. Hartman wrong?
Well, the maintenance costs of the level 2 chargers on a quarterly basis, for the most part, it's about $200 per charger per quarter. And the DC fast chargers represent a much larger cost driver than the others. The purpose of this program was to create a reliable charging network that would promote adoption of EVs in Maryland, and we still believe that the utilities could have a role in achieving that.
Are the ones that are being replaced or proposed to be replaced, are those ones that are actually being used by customers?
Though I don't have utilization figures on hand, many of the chargers throughout the network do have utilization, though we could get back to you on that in the future.
Yeah, because I remember, I think the last hearing we had, there were a lot of chargers that just aren't used. So it kind of begs the question as to why we're replacing ones that aren't being used, and rather than just ripping them out. But thank you, sir.
Commissioner Barber? No. Commissioner Litton?
No.
Okay, so go right ahead.
Good morning, Chair, Commissioners. Juliana Bell on behalf of the Office of People's Counsel. We submitted brief comments with 3 points. But before I get to those, and recognizing that we have a full room and a long meeting here, I just wanted to touch on some brief context here. The first point may be obvious, but I wanted to touch on what OPC's role is and what our interest is. Why are we weighing in on whether you bring a cable or don't bring a cable under BGE's proposal? We don't represent EV drivers. Obviously, we represent residential ratepayers. But in representing residential ratepayers, we have an interest in ensuring that chargers operation and maintenance maximizes, that these chargers maximize revenue, protecting ratepayers from having to pay unrecovered costs, costs that aren't recovered through the EV driver operation are being recovered from ratepayers. Second, I wanted to just touch on the context of the docket itself, which my colleague at staff just highlighted. But if you remember, this was initiated in 2019, this docket, after a petition from stakeholders, and the order approving it stated in part the following, quoting from the petition. The signatory parties, meaning signatory parties to the petition, point out that while ratepayer financing of these costs, quote, may in the short term result in a small increase in electricity costs to consumers, the electric distribution revenues generated by the increased EV use, quote, are likely to wholly offset the residential bill impacts attributable to this portfolio as the state progresses toward realization of its 2025 EV adoption goal, which I believe was something like 300,000 EVs in the state of Maryland at the time, and I think our comments touch on this, but we're now at about 150,000. Obviously, that hope hasn't been realized, and the context today is different than in 2019. In the most recent Phase 1 reports, the utilities reported net financial losses to own and operate the chargers, both for BGE and, is my understanding, for each of the participants. BGE's updated charger network plan amounts to an admission, in our view, that it can't realize the required uptime at some of these charging stations. And it's made some efforts, as highlighted in the recent legislative style hearing. It's tried triage kits to stockpile parts and have them at the ready for folks who are maintaining these. It's implemented truck rolls, costly truck rolls to try and maintain these charger stations. And OEMs aren't prioritizing its requests for parts for aging chargers. So what's happening as a result is that costs are building up in regulatory assets that eventually will be considered in rate proceedings. The surrounding circumstances have also changed. We've had a pandemic since then. Ratepayer affordability, which was always, I know, at the forefront of the Commission's mind, maybe is more so lately after multiple repeated rate increases, particularly at BGE over the last 7 or 8 years. So the upshot is that in this context, the Commission, in our view, has an opportunity to continue its efforts at curtailing expenditures that for all on these chargers, which from all appearances are cost ineffective. So that brings me to our 3 points. I mean, in our letter, we think that BGE should not replace the chargers it removes from its network because replacement would add unnecessary costs that ultimately, if the chargers are not profitable, would end up with residential and other ratepayers. We think BGE should begin decommissioning underperforming DCFC sites and transition those sites to their respective site hosts. We do recognize that decommissioning will require some coordination and planning with those site hosts. We made a recommendation in our filing that BGE submit a supplemental filing by June 2026, detailing the status of its right of entry agreements with MDOT. And perhaps there may need to be other decommissioning provisions or decommissioning plan filed by BGE for any other sites as well. We do oppose MDOT's request that BGE's Phase 1 EV programs be extended. And lastly, we oppose BGE's request to replace chargers at select sites with bring your own charger cord infrastructure, we think that adds an unnecessary cost and is inefficient for reasons we discussed further in our April 1st, 2025 filing recently. I'll stop there and see if the commission has any questions.
So, any questions for OPC? Commissioner Linton?
Yeah, thank you, Mr. Chairman. Just one. The People's Council is, good morning.
Good morning.
The People's Council is one of the members of the ZVIC Council. Can you let me know, and I guess let all of us know, if what the company is proposing here today is in line with what ZVIC has been planning and anticipates the state's overall movement in the EV industry or world. If what the company is proposing now matches what ZVIC is looking to see going forward, or are we at cross swords? Are we not moving in the same direction?
I think I'm going to have to get back to you on that, Commissioner Linton. I don't participate directly in the ZVIC meetings, but you're right, OPC does. But we can follow up with you on that.
Okay. All right. Thank you. That's all I had. Thank you.
Okay.
Mr. Chair.
So you mentioned and we saw that there were comments filed by the Maryland Department of Transportation. Is there anybody here from MDOT? All right. Did staff have any communication with MDOT other than to read the comments that they filed?
Good morning.
Sure.
Mr. Chair and Commissioners, Drew McAuliffe on behalf of staff. Yes, I had old Eva and myself had a couple meetings with MDOT. And they had just expressed concern that the timeline that BG proposed of transitioning it, I believe, was 3 months, that was unworkable. It'd be more like 18 months because their fiscal year is already closed, so they'd have to wait till the next year and things like that. Yeah, so they just expressed concern, and apparently these agreements are pretty complicated and not as simple as just saying, hey, we're not going to operate these chargers anymore, or we're just going to give them to someone else. That was also an issue that was stressed to staff, that it's not that simple. So just to respond to OPC's comments quickly, if the commission were going to go the route of decommissioning, I think we'd like to see at least a plan first, or just to make sure it's not haphazard and that the site hosts understand what's occurring and when those deals roll off and things like that. That way we don't run into any legal issues as well. But yes, we did have a couple meetings with MDOT.
So I guess one question though, I mean, did you have any reaction to their suggestion that we extend the programs to June and December of 2028?
Yeah, I don't recall that coming up in the meetings. Yeah, that was a little longer than I thought they would. I know some are running out now, so I think the phase 2. I think what they're referring to is the phase 2 as well, because I believe those were asked to go to 2028, and that was also a concern that MDOT brought up on our meetings, is that a lot of their agreements end this year, and they needed something, a commission order or something, to say that these chargers have been extended so they could get their legal sign-offs, and obviously the holiday time period and everything made that difficult. So I think they wanted just an assurance that these chargers are allowed to operate until then, so they could get their legal sign-off and things like that.
Okay, so before I turn to the company, Mr. Hartman, do you have comments you want to make?
Good morning. My name is Lanny Hartman. I'm a BGE ratepayer. I brought my BGE bill here today, and there's a donut chart on there. It's got electric supply, electric delivery, taxes, and fees. And I imagine somewhere in there is the cost of this program. I'm not sure exactly what it is. I've heard everything from a few cents to $1 or $2 per month that each and every of the over 1 million BGE residential ratepayers are paying for this. I'm also an EV driver. I was an enthusiastic supporter of this plan. I sat here in 2018 and supported it. And
support was based on the promises of reliability. There was going to be like solid as the grid. Over time, it's turned out not to be such. I advocated for a law, sponsored by Delegate Fraser Hidalgo, the Electric Vehicle Charging Reliability Act of 2023, which got us an important thing, the data. In addition to the 97% uptime, I thought that the data is one of the most important things. And I was here about a year ago, I think it was December 18th, 2024, when Pepco asked for, I think, $1.2 million of existing budget to replace some of their charging stations. And I had distributed at that time, a year ago, pictures and a graph of Acredale Community Park, which I think you have in front of you from last year, which showed that at about March of last year, according to the data that was available then, it just went down to zero usage and flatlined. And that $1.2 million for replacing the equipment was approved. Evidently, the budget was $10,000 for each level 2 station to replace them. So I decided, since we have this data now from the quarterly reports, I'd take a little peek to see how they performed the new replacement ones of this. They appear to be the Zerova models that are proposed by BGE. And I look at the uptime for April and May of this year, looks good, 100%. But I've been there myself, and they were all down. And it's reflected here in the data for June, 65% uptime for all 4 of those $10,000 replacements. July, 30% uptime. September, 59% uptime. And the reasons for the failure are all over the place: hardware, area power outage, network connectivity. So I bring this to, this is not the only such place. The Kensington Town Hall, I visited that place earlier this year. They were all down. Brand new replacement units at $10,000 each. I want to make sure that you're aware of this as you make your decision. I personally believe that the ratepayers should not be spending money on this. The benefit cost ratio is way out of whack. There was talk about the chargers at BWI Airport. That's been a particular concern for EV drivers, especially the ones that drive for rideshare, because 6 of the 10 BGE stations are in that rideshare lot. And a number of us kind of adopted that place because they are down so often. And these people who drive rideshare, I'm not one of them, but you can tell they depend on that to make a living. And there's been times, there was a week or so where they were just all dead, blank screens. And from talking to these people, it turns out that they have to be in that rideshare lot because of the geofence of their rideshare apps. So if can't charge in that rideshare staging lot, they are going to lose out on economic opportunities to give rides. The good news on that front, and I want to make sure that you know this because I didn't see it mentioned anywhere else, is that literally right across the street there's a 7-Eleven Shell gas station, and they're putting in 6 fast charger ports there. I was there yesterday. I provided a picture with my written comments. That station looks ready to open as soon as they do need a transformer, but that will help with any concerns about what happens to fast charging at BWI Airport. there's also been a Nevi site that recently opened in the last few weeks. It's got 12 stalls. It's subject to the 97% uptime of the Nevi requirement, and that should also help. So there is good news with charging from other service providers coming into Maryland. So, yeah, and another concern I made in my written comments was about the potential resetting of the reliability reporting. If these are allowed to be replaced by the end of the year, I know that staff wanted 12 full months of data before looking at the potential of penalties. If they are allowed to be cut off just days before that 12 months is up, my question is, I wonder if that has any kind of effect on the potential of looking at those penalties, since it wasn't a full 12-month. So, yeah, speaking of penalties, my BGE bill is due January 2nd. For those of us that are ratepayers, if we don't pay that, I do think that we will get a penalty. Thanks.
Okay, any questions for Commissioner Barbe?
Thank you, Mr. Chairman. Lanny, thank you. Just for my edification, maybe you've answered this before for Acredale, maybe not. Are there any amenities at all? These are level 2 chargers, which means that you're getting like 25 miles of charge per hour. Are there any amenities near this?
No, it's not. So it's like on a dead-end street. There's a park there. It's nice if you are scheduled to go to that park, but there's not, like, for example, the 7-Eleven that I just mentioned is getting a fast charger. It's open 24 hours. Go in there and get your Slurpee coffee.
Right.
No amenities there.
Okay, well, that would explain why nobody's going there. Okay, thank you.
Anybody else? Okay, so let me turn to the company.
Good morning, Chair Hoover, Commissioners. Dan Herson again for BGE. I'm filling in for Mr. Michelle today, so I brought some friends with me to answer questions. Stephanie Leach, our Manager of Strategic Programs, and Elena Martinez-Hart, our Principal Business Program Manager in the EV Group. And I'm going to ask Ms. Leach to give a brief synopsis of what exactly we're asking for today, because I think there may be some confusion among some of the parties about specifically what we're asking for. But before I do that, I just, listening to Mr. Hartman's comments and OPC's comments, I don't think that today is really meant to be a referendum on BGE's EV program. The commission has the phase 2 proposal before it, and we presume the commission will issue a decision at some point on that proposal about the future of the EV program in general. But I would be remiss if I didn't say that this idea that somehow the BGE program has been a failure or has not met expectations, I firmly push back on those statements. I sat here 5 or 6 years ago or whenever it was, and yeah, we made a lot of representations. We had a lot of things to say, and our thought was that we put forth a good, solid program. Has everything happened the way that we thought it was going to happen? No. As OPC pointed out, there's been a lot that's happened between now and then. There was COVID. That was a huge impact on this program in terms of people being out and about, using chargers, as supply chain issues, able to get folks to maintain chargers. When we sat here in 2019, nobody knew that was coming along. There's been changes in federal policy on EVs in terms of what's supported and what isn't. But I'll just remind everybody that when we first put the proposal forward, the pushback we got in large part was, hey, we don't want you putting chargers in areas that are going to eat into what the competitive market is interested in. So as a result, this commission, and we supported this, directed us to put chargers in areas where maybe chargers weren't being used as much or where chargers weren't being cited as much. So that's why you see our chargers in parking lots at government buildings that maybe aren't open all the time, or on state park land, or behind a library, that sort of. We're not at gas stations. We're not in the middle of shopping centers, that sort of thing. So it really shouldn't be a surprise that our chargers aren't being utilized as much as some other chargers. However, I believe that a rising tide raises all boats, and that there is value in having the BGE EV charger network out there. People know about it. Most of the chargers, a majority of the chargers do work most of the time. 97% reliability, that's a high number, and we're trying to meet that, and that's part of why we have the filing that we have before you today to help us get to that point. But I do believe there is value in having these chargers out there. It helps tamp down range anxiety. If an EV driver knows that there's a charger there, maybe they're not going to use it once or ever, but they know it's there and there's value in having it there. So I'm going to turn it over to Ms. Leach to give a brief overview of what we're exactly asking for today. But again, I just want this commission to remember that this should not be a referendum on the company's entire EV charger program. And we'll both be available for questions should you have any. Thank you.
Good morning, Mr. Chairman, Commissioners. Stephanie Leach from BGE. I just want to go back to September 12th, a reliability hearing, and some comments that were made from stakeholders and some requests that we heard and took back from this commission as it relates to our reliability at the time, and some directives to go back and really think through a plan to improve our reliability score. And we really took that back and thought about it over the last several months on how could we meet customers where they are, meet customer satisfaction, and improve our reliability score. We also know that there are others in the market, as you've indicated, who can do this job better related to DCFCs. And so that is a space that, as we've indicated in our filing, we're not looking to be competitive with the Teslas and the Electrify Americas of the world. And we know our space is really in the level 2 charging game. So as we've learned over the last couple of years and really taken in what was a research and development opportunity, a pilot, we are prepared to move this forward into the next phase of phase 2 program. So as it stands right now, our reliability score at the end of the year is looking at about a 91% uptime. But even with the O&M that we have included in our phase 2 filing, we know with the network as it is now, it's not going to be sufficient to keep all of these chargers online, which is why we'd like to decommission some of our poor performing chargers. We have 297 L2s on our network. We're talking about ripping out and replacing 36 of those. And that is all included within our phase 1 budget. We are not requesting any additional money for this rip and replace project, and I want to make sure that that's clear here. There have been talks about this not making revenue, and that was not the intent of the phase 1 program. It was really to put charging infrastructure in places that we know the other market is not going to go into. And on that note, when we took back this request from the commission, we even wanted to think outside the box. Could some of these sites be taken over by some of these more competitive markets? So we approached some of those bigger networks to say, would you be interested in taking over some of these sites? And they said no, because there aren't the amenities at these locations that would make it enticing for them, that would bring in the revenue from them. So we know that if we were to step out of some of these locations, no one is going to backfill us. And so to your point, Commissioner McLean, why should we replace these chargers and not just rip them out? It's because no one's going to go back in and do it for us. And so that's why we think it's important to rip out the ones that are failing and put them in with new equipment, with brand new warranties that will last a significant amount of time longer. As we see the market continue to transform, policies continue to evolve, we will have brand new equipment that will stand the test of time. So that's our phase 1, or our part 1 part of this is the rip and replace, ripping out those failing level 2 chargers, replacing them with new equipment. Part 2, which was the BWI site decommissioning, I think there is some misunderstanding, and even potentially from MDOT, on what we're proposing here. We've had several conversations with MDOT dating all the way back to the beginning of November, which we thought were very productive. We never gave them a 3-month timeline. We know that this is something that takes several months, lots of discussions. We know they're past their current fiscal year, even fiscal year 2026. They have indicated it would take 12 to 18 months, and we are continuing conversations with them on what it would take to transition these sites or transition these sites to a third party beyond MDOT if they're willing to work with a third party. Mr. Hartman shared how valuable the rideshare lot is. We agree. It's not something that we're looking to decommission right at the end of this year, but we want approval to start those conversations about what it would take to take those chargers off of BGE's network and start to socialize that with MDOT, Parks and Recreations, Anne Arundel County, whoever is willing to absorb that into their own project budget to ensure that we can get reliable charging at that site. As I believe you all are aware, that those locations, the rideshare lot and cell phone lot, were funded through a federal grant and were not actually funded through the Phase 1 budget. And so we want to make sure that we can keep those sites running, as they are very lucrative for EV drivers who rely on that valuable location. Part 3 of the budget, or on the proposal that we've outlined here, is a bring your own charger pilot. And I say pilot because this is something that we're not looking to roll out across all of our network. It would be very small scale, looking to identify a handful of sites where there's an opportunity that we see constant vandalism, constant O&M challenges, where we would replace a single charger at each of these sites with a cableless charger that requires hopefully less maintenance moving forward, and we would pilot this to see how effective it would be if we are seeing drivers use these chargers, and potentially replace more in the future if that were successful. So I just wanted to make sure that that was clear what we were bringing forth for you today. We are proceeding with our rip and replace. We really are looking for some sort of order on the decommissioning phase, and then part 3 of this is something we would only move forward with when we receive an order on phase 2.
Okay, Commissioner Barbie.
Thank you, Mr. Chairman.
Actually, you can just.
Oh.
Yeah, questions for the company, so just stay at the podium there, so go ahead.
Yeah, okay, thank you very much. So a couple of things. First thing, level 2 chargers at locations like that community park that doesn't have any amenities. I don't think that's a valuable proposition as an EV driver myself, because if you're going to be waiting 2 hours to get 50 miles of range, you need to have an amenity. And so my thought with respect to those locations like this park and others like them that don't have any amenities is that we should just remove those chargers and not replace them. Please give me the counter argument to that.
I can't speak to the park. I think that's a Pepco park that Mr. Hartman indicated in his letter.
Do you not have any locations similar to this then?
I can speak to parks, I guess,
Okay.
as an example. I think, again, playing the long game here, you know, parks are a great example of a place where you go and you are there for a sustained amount of time. So it might not be that you are parking there with the expectation that you're getting a DCFC type of experience. You're parking there to enjoy a park. You might be there for an hour, 2 hours, 3 hours, and you might not necessarily be on an empty battery needing to refill. I think it's also important to know that some of these drivers are multifamily drivers and have indicated that they rely on public charging as their means of charging. So pulling any sort of public charging out is to the detriment of people who don't have a single family home and dedicated home charging.
Yeah, you see, the way I look at it is that if I'm running low, I think I would want to have amenities, especially if it was only a level 2 charger. But okay, we can agree to disagree on that. Second question, with respect to the level 2 chargers.
Commissioner, can I point one other thing out, just because I think it's important to note? When we cited these chargers, we didn't just pick places and say, well, we're going to put them here. We actually had parties approach us. So it's not as easy as just saying, well, we're not going to be here anymore, because we actually have contracts and agreements with state agencies, park services, counties, that sort of thing. that have provisions in them that if we take our ball and go home, we may have to replace it with something or figure out something else. So I'm not saying that your points
Okay.
aren't valid. I just want to remind the commission that it's not as easy as us just saying, well, we're not going to be here anymore.
Okay, that's useful. Thank you. The second question had to do with the level 2 chargers at BWI. I should know the answer to this, but I don't. For whom are these level 2 chargers intended? Is it for people who are plugging their car in and then flying somewhere? Or is it for rideshare folks or Uber drivers? For whom are these level 2 chargers intended?
Yeah, so just to clarify, they are level 3 chargers.
Oh, they're level 3.
Yes, and we're talking about, there are 3 sites at BWI. One of them does have level 2 chargers. We're talking about decommissioning the cell phone lot and the rideshare lot, which both are predominantly used by rideshare drivers or individuals that are waiting, to pick up people who are traveling at the airport.
So at the cell phone lot, I've driven there and I have noticed them. Those are level 3 chargers?
Yes.
Okay, so are there any level 2 or level 1 chargers for people who are going on vacation?
I believe so in the parking lots at the airport, but they're not BGE. They're not on the BGE network.
Okay, they're not yours.
And Elena, you can correct me if I'm wrong. We do have one level
Actually, if you could
chargers.
tell us who you are and then go ahead.
Yes. Good afternoon, Commissioner and Commissioners, Chairman. My name is Elena Martinez-Hart. I'm a Principal Program Manager for the EV Smart Team. We do have one level 2 site at BWI that is for parking for long-term or short-term, depending on the customer's use case.
Well, since you're knowledgeable about this, I mean, wouldn't level 1 be good enough? I mean, your car's going to be there for 3 or 4 days. I plug my car in at home into a regular wall socket. I mean,
Yes, for most destination charging, level 2 is the optimal view for most EV owners, but like for workplace or long duration stays, level 1s would be applicable or appropriate. But for the parking situation that we have, we moved with level 2s because we deemed them the most appropriate.
okay. And final question on this issue of bring your own cable. Which is something that's happening in Europe. But what I want to know is the bring your own cable pilot, is that intended for level 2 or level 3 or both type of chargers?
So the BYOC has advanced in the output, so we are looking at something that would be equivalent to, if not exceeding, what our level 2s currently provide.
But not level 3. Those would be too thick, wouldn't they?
Correct, yes. There is no BYC option that I'm aware of to date that has a level 3 component.
Okay, thank you. I'll just conclude that by saying that, well, I wasn't here in 2018 when this was all being designed. It was even before I owned an electric vehicle, and I think it was unfortunate that a lot of the EV charging policies of America were formulated at a time when almost nobody drove electric cars, and that's probably explains why there's so much dysfunction in the market. And I don't blame you for that. It was designed the way it was designed by people who didn't drive electric vehicles. So how can we be surprised by the outcomes? Thank you, Mr. Chairman.
Any other, Commissioner Klain?
Good morning. Or good afternoon, I'm sorry. The 36 chargers that you're proposing to rip and replace, are the locations of those chargers, are they desirable in terms of as desirable as a government location can be?
Yeah, so we did evaluate these sites for both high utilization, high priority, and poor performing level 2s. So we wanted to ensure that what we were replacing would have a utilization element to it in the design of the plan.
Okay, so when the chargers are actually working, they're being used.
Yes.
Okay. And Mr. Hurston, you brought this up with the contracts. I'm guessing you don't know what the terms or potential impacts could be if you ripped these things out and didn't replace them.
Yeah, Commissioner, I'm trying to remember, because I actually negotiated some of them, but it's been a while since I've looked at them. I don't think we had any like damages provisions in there, but I think we had obligations to find suitable replacement sites. So again, I don't think it was as simple as if BGE decides that we just don't want to be doing this anymore, then we can just go home. And now, if the commission decided we shouldn't be doing this anymore, I
Right.
had provisions in there to account for that. But in terms of us just unilaterally making those decisions, I don't believe we would be able to do that without offering some sort of replacement.
Sure, but there are some chargers that you're decommissioning and not replacing, is that correct?
If we are,
As part of your proposal, is that,
yeah,
or,
right, yes, yeah, if we are, we would make sure we have that understanding with the counterparty and that we're not just doing something on our own.
okay, so that's already been worked out with,
Yeah, I don't know if it's been worked out yet.
And just to address that, so in our right of entry agreements, there is language that talks about if both parties agree, we would restore the property to its proper state before the chargers were there.
okay. Thank you, ma'am. I appreciate it. Thank you, Mr. Herson.
Mr. Litton.
Thank you, Mr. Chairman. I just had a quick question about the bring your own charger concept. I'm sorry?
Cable.
Oh, cable, I'm sorry, yes. Cable. Well,
Cable charger.
obviously I'm not familiar with it, so that's part of the reason why I was asking the question. I've not been to Europe lately, so, or at all, so I can't say that I've seen it anywhere else. So am I to understanding that for that solution, the driver will, is there basically just a pedestal there or something and just plug into it?
Correct.
Like a wall socket, but not without the wall?
Exactly. Yeah. So the intent there would be it's just an outlet that a driver that has a level 2 charger could plug into, and this would help, broaden the EV group so that they wouldn't have to have adapters, or broaden the group to, e-bikes or e-motorcycles that would also have EV charging on their hand.
Yeah, that makes a little more sense. I think it's from my perspective. Obviously, I was around back when the original pilot was adopted, and there was some of the background that was stated is accurate. There was an intent on making sure that the utility did not go into areas where they would be competing against other companies. And the primary reason for that was because at the time we had a number of other electric charging companies that were actually here. And they were very supportive of the commission moving forward with this initiative, which even back then was confusing to me because I didn't know why they wanted to compete with you, but they wanted to. So they thought it was a good idea. One of the important points, which I think we've heard a little bit about today, was that the utility company participating would encourage those companies to also participate, because there would be the development of what we called back then the make-ready infrastructure. Basically meaning that if there were chargers across the street, then the infrastructure was nearby to add chargers at another facility close by, so that you would start to have development of chargers in an area, whereas opposed to a company wanting to build chargers in a region, and they would have to pay for everything, all of the upgrades, all the way up the line to as far back as a substation, which made the cost of putting the infrastructure in unaffordable and not cost effective. So there was some rationale to why it was done the way it was done. I think it's important for us to as a commission at least to understand also what the long-term strategies is the state's going to implement. So I asked the question earlier about what ZVIC was doing, and if the state has concluded that this is not a policy that it looks to embrace, and I really haven't heard that. So I personally am not looking to take the lead on that yet. I think that there's from a national perspective, certainly there's been some federal change in how the support for electric vehicles has happened over the last year and a half or so. But there's also been a lot of market trends pointing in the other direction, suggesting that new electric vehicle companies are starting to enter the markets here in America. And so what that's going to mean going forward, I don't know. But it is I think the point is that in other parts of the world, these vehicles are still selling very well and are still very popular. And so along with the large load issues that we have to think about all the time. This is not an issue that's going to just disappear because some of the policy changes might have happened at either the federal level or elsewhere. So I'm hopeful that as we move forward with these new ideas, that some of them will work a little better in the areas that we're looking to implement them.
Okay. So I know that you have other governmental requirements you have to make from other agencies. Is this particular proposal intertwined with that effort? Because I guess what I'm trying to get to an answer to is, do we need to act on this today, or can we take this under advisement and kind of work on it?
As we've mentioned, we're moving forward with the rip and replace with our existing budget. Part two, we would like to get a decision on in order to proceed with the decommissioning conversations with MDOT or with other state agencies. There is not a legal need to make a decision here today.
Okay.
So, no.
Okay, all right, in that case, we're going to take this under advisement and get something out relatively shortly, but probably not tomorrow or the next day. So.
Chairman, could I just, Julie Bell with OPC, just wanted to touch very quickly on two things. One, Mr. McCall from staff earlier said that staff would have a preference for some sort of decommissioning plan or structure if the commission moves forward with our decommissioning recommendation and BGEs, and OPC would support that. And secondly, I don't have friends in the room other than Brock, as Mr. Dan from BGE does, but I did have somebody lurking on YouTube, Isaac Lindenbaum, who prepared the comments, Commissioner Litton, in answer to your question about ZVEC. I have a very abbreviated answer that ZVEC is prioritizing L2 chargers over DCFCs, if that gets to your question. OPC's position is that that should be handled by private entities and not paid for by ratepayers. We don't sign on to all of ZVEC's recommendations. We participate in ZVEC, but don't necessarily adopt all of what you see that's published by ZVEC. So I hope that's marginally helpful, and if you'd like us to provide an additional answer, we can do that as well.
No, I appreciate that. I just wanted to make sure I understood if there was a walk, I'll just use the phrase, I know they're not using the phrase, but I use the phrase walk back on electric vehicle charging, or if there had been some other policy shift that I was unaware of. But I appreciate the response. Thank you.
Okay.
Okay, item number 21 is the recharge pilot extension request from Southern Maryland Electric Cooperative.
On November 25th, 2025, SMECO filed a request to extend its managed charging program to the earlier of April 1st, 2026, or such time as the Commission issues an order on SMECO's Phase 2 application. In its request, the cooperative also seeks authorization to extend the availability of EV time of use rates, its public charging program, and its multi-unit dwelling charging program, to such time as the Commission issues an order on SMECO's Phase 2 application. SMECO is currently authorized to deploy up to 35 Level 2 EV charging stations at multi-unit dwellings, and in response to a staff data request, the cooperative stated that 2 such stations have been built to date, both at the same location. It currently has plans to build 6 additional charging stations at 4 other locations. SMECO does not expect to build all 35 stations authorized as part of its multi-unit dwelling charging program. The managed charging program will be funded by unspent funds from the SMECO's data access program, leaving no additional need for funding. Staff recommends the Commission accept the revised tariff pages and grant SMECO authorization to continue their EV programs with an effective date of January 1st, 2026. Staff's available for questions.
Any questions? All right.
Good afternoon now. Damon Krieger on behalf of Southern Maryland Electric Cooperative. I think staff has summed up our filing and hopefully it's not as controversial as in-depth as the last one. We're simply seeking to continue our existing programs which expire under their current terms as stated in the tariff. And so without permission from the commission to do so today, so I think to the earlier matter, there wasn't as pressing an issue. For us, there is, because our tariff currently expires December 31st. Without that authorization, certain programs will end, which will be disruptive to our customer members. So with that, we're available for questions.
Sure. Any questions for SMECO? All right. Hearing none, I move we grant the extension authorizing the cooperative to continue its Phase 1 programs with a filing with an effective date of January 1, 2026. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barbet.
Aye.
I vote aye.
Item number 22 consists of revised tariff pages regarding SOS rates from SMECO.
The instant filing proposes a 5.75% increase in the SOS demand charge under Schedule WSSC, which serves a Piscataway wastewater treatment plant. This increase is driven by an increase in network integrated transmission service charges attributable to the rate class. Staff recommends that the Commission accept the proposed tariff pages for filing with an effective date of January 1st, 2026.
Okay, any questions?
David Krieger, again, on behalf of SMECO, nothing to add, and happy to answer any questions the commission may have.
I take it there's nobody here from WSSC, right? Okay. All right, with that, I move we accept the tariff revisions for filing with an effective date of January 1, 2026. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barbet.
Aye.
I vote aye.
Item number 23 is a true-up to the SOS Rider G rate from SMECO.
Good afternoon, Chair and Commissioners. Andrew Schlicht on the behalf of staff. On November 26th, 2025, SMECO filed tariff revisions for their Rider G rates. This is part of an optional program for SMECO members to participate in. If members seek to have their energy usage sourced from renewable resources, this rate covers the cost of acquiring the necessary renewable energy credits. The proposed tariff marks a 60% decrease from last year's rate. This change is due to the cost of RECs being below what was forecast, leading to a significant overcollection in 2025. Additionally, the forecast cost of RECs for 2026 is below that of the REC cost this past year. SMECO filed these revisions to begin on January 1st, 2026. I will then turn to our staff counsel for additional comment.
Ruthie Herman for staff. We just wanted to point out that there's an error on page 4 of staff's buck sheet where it says near the top about the 2 Comar sites prohibiting SMECO from marketing SOS. That's actually incorrect. There was a change in law during the 2024 session, and in 7510, so that's actually incorrect. Thanks.
Okay, any questions for staff? Seeing none?
Damon Krieger for SMECO, still here. I appreciate Ms. Herman's clarification of staff's buck sheet. We are excited that the rate for our Rider G program is decreasing, and hopefully that will encourage additional customer members to participate in the program. And with that, available for any questions.
Any questions? Seeing none, I move we accept the tariff provisions for filing with an effective date of January 1, 2026. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barbet.
Aye.
I vote aye, and our best holiday wishes to you and all the other folks at the cooperative.
Thank you very much. Sure.
Item number 25 is a Warrior Run surcharge update from the Potomac Edison Company.
Good morning, Mr. Chair and Commissioners. Charles Herbert on behalf of staff. Potomac Edison Company proposed to update their tariffs to reflect the proposed surcharge project for a period of January 2026 to December 2026. In case number 8797, the Commission approved a settlement agreement that authorized implementation of the Warrior Run surcharge. Following the approval of an agreement for termination of the PURPA contract on June 21st, 2023, the surcharge became robust to fluctuations in energy and capacity markets and now only depends on the contract payments as required by the agreement. This year, Potomac Edison has proposed two distinct allocation methods for the cost recovery. The first method is the typical allocation method that Potomac Edison has used previously, or the original allocation, and the second method is an alternative that would allow residential customers to see a decrease in the surcharge. Under the company's original allocation, the current residential rate of 0.833 cents would be increased to 0.862 cents for 2026. For a nominal residential customer using 1,104 kilowatt hours of electricity per month, the bill impact in 2026 of this surcharge would be $9.20 per month. Under this method, all non-residential customer classes would see decreases in their surcharge rates. Under the company's alternative proposed allocation, the current residential rate of 0.833 cents will be decreased to 0.806 cents for 2026. For a nominal residential customer using 1,104 kilowatt hours of electricity per month, the bill impact in 2026 of this surcharge would be $8.90 per month. As with the original allocation, all non-residential classes would see decreases in their surcharge rates. Staff reviewed the documents that PE submitted developing the rate, and staff believes that the components have all been calculated in accordance with the termination agreement. Additionally, given that PE's proposed alternative allocation will result in residential customers seeing a decrease in their rate, while still allowing decreased rates for the other customer classes, staff recommends acceptance of the proposed surcharge under this method from January 1st, 2026 through December 31st, 2026. Staff is available for any questions.
Okay, any questions for staff?
Good afternoon, Jessica Reba on behalf of Potomac Edison. Thanks to staff for the analysis. We have nothing to add, but are here in case there are questions.
Any questions for PE? Okay, I move we accept for filing the revised tariff pages under the company's proposed alternative allocation with an effective date of January 1, 2026. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barbet.
Aye.
I vote aye.
Okay. Item number 26 is a request from Amoresco Inc.
Good afternoon, Chair, Commissioners. Michael Dean on behalf of staff. M26 is a filing by Amoresco requesting a conversion of 3 2-megawatt aggregate net metering or ANEM solar facilities into community solar energy generating stations or CEGES with an update of the associated subscriber organizations through the waiver of regulations. Each of the 3 2-megawatt ANEM are located with 3 2-megawatt CEGES solar facilities, which per the filing are essentially completed. The solar facilities are located on formerly mined property in Garrett County, which is in the Potomac Edison Company service territory. The filing requests waivers of 3 groups of regulations, 2 of which are in the alternative. First, the filing requests a waiver of COMAR 20.62.03.07, which allows the conversion of solar net energy metering facilities to CEGES. This regulation states a subscriber organization may apply to the Commission to convert all or a portion of an existing solar generating system that participates in net energy metering under Public Utilities Articles Section 7-306 Annotated Code of Maryland into a community solar energy generating system under the program. While the 3 ANEM designated facilities are nearly complete, they are not existing net energy metering facilities. The net metering statute at Public Utilities Section 7-306A4 requires an eligible customer generator that owns or leases a solar energy facility to be located on the customer's premises or on contiguous property, and there is no third party for the electricity at the site of the 3 solar facilities in Garrett County. Since the 3 facilities are not existing net energy metering solar generating systems, they cannot use this regulation to convert to a CGIS. The following requests an alternative: a waiver of the CGIS application requirements of COMAR 20.62.0303 and the Community Solar Q requirements of COMAR 20.62.0304, so that the nearly completed A&M solar facilities would essentially be converted or deemed to be CGIS. However, staff cannot recommend that any project bypass the administrative and procedural steps of the Community Solar Energy Program. Waiver would be inconsistent with the first come first served process that all other projects must comply with. Instead, Ameresco has the option to withdraw the 3 2-megawatt A&M designated facilities and apply to have them qualified under the CGIS program as it did with the other solar facilities in the 3 Swanton project groups. Lastly, the following requests a waiver of COMAR 20.50.09.06B and 06D regarding the operation of the electric company's interconnection queue. The regulations provide that with any material change to a project, a new interconnection application must be filed, and that in the filing request this waiver so that the existing current interconnection queue position for the 3 projects be unchanged with any change to the solar facilities being converted to CGIS. As this would be the first time that the Commission is being requested to intervene in the order of projects in the interconnection queue, which is maintained by the electric company, staff recommends that the requested waiver be rejected, as this would essentially establish a bad precedent. In addition, staff supports the integrity and fairness of the interconnection queue process of the electric companies participating in the CGIS program. In summary, because the 3 designated A&M solar energy facilities do not meet the statutory definition of customer generator necessary for net metering, as there is no third-party load at the site, premises, or on contiguous property, the requested waiver of regulations to allow the conversion of the A&M facilities to CGIS should be denied. Ameresco may choose to apply to have the 3 nearly completed solar energy facilities qualified in the CGIS program. Lastly, no waivers should be considered regarding the regulations which would be intervening in the order of projects in the interconnection queue of the electric company. Regarding the recommendation, the Commission should deny the requested limited waiver of COMAR 20.62.03.07 or of 20.62.0303 and 20.62.0304 to convert the 3 A&M designated solar energy facilities of the Swanton projects into CGIS, and of COMAR 20.50.09.06 regarding the electric company interconnection queue position. Thank you.
Any questions for staff? Commissioner Litton.
Yeah, thank you, Mr. Chairman. Good afternoon. Can you tell me if at any point did the staff or anyone else ever give any kind of approval or certification to these projects as net metered projects? Because they appear to think that that's what they are. So how did we get to that point?
I believe that when they submitted applications for the subscriber organizations, they were listed as A&M projects.
And listed in our system or on their application?
Oh, excuse me. I've been informed that they don't actually apply for that. That's with the electric company.
Okay, so the company thought that they were a net metered project.
Commissioner Linton, it's our understanding that they applied for interconnection and listed these projects in questions as A&M projects. So that would have gone through the utilities process. The tariff in PE would not have allowed this type of project to be considered A&M because a direct connection such as this is primarily for a technical efficiency when the existing infrastructure is not capable of exporting power. So without a load on that site, this would not have been allowed to operate as A&M under the PE tariff.
So, I was trying to find where I saw this at in the filing. It might have been in the company's request, but I thought this was a project that was providing the supply to another facility that was government owned. Is that correct? Or did I misread that?
I believe that's the intent of the Amoresco.
So, okay, well, I can ask that to the company when it's their time to speak, but you also mentioned that the company's queue could be impacted by this project if it was switched to a CSEG. The company didn't file anything today that I saw.
You mean Potomac Edison?
Potomac Edison, yes.
We had a conversation with Potomac Edison, and they did not indicate one way or the other regarding the filing. However, it's staff's understanding that at least the current interconnection as designed would probably be the same for the new, if it was reapplied for.
So does that suggest that they are behind in the queue or at the back of the queue, or is there a queue at all, or?
Yes, there is a queue.
Okay.
I don't want.
Yeah, they're not here.
Oh.
No help.
I understand that there is another project on that segment of the system.
Okay.
But that is also owned by Amoresco.
Oh, so they're in the queue behind themselves. I mean, if that's the case, that's fine. I'm just trying to understand what the queue concern is.
Commissioner Linton, the interconnection study has been done, I think, for the facilities that are on the site, as well as this one, which was proposed as A&M, which they would like to convert. So I think the Amoresco is concerned that if they are not able to simply convert this, they would lose their position in the interconnection queue and have to go back and go through a restudy. That is not our understanding from speaking with Potomac Edison. There may be a need to refresh the study and examine as to whether or not the export capacity, either on the feeder that has been designed and may be built for them already, or the substation. But from we understand the concern about having to sort of go to the back of the line. But what we're talking about here, there's the interconnection queue, which requires them to go through a process where they study the interconnection and tell them what needs to be built in order to achieve it. We do not have the understanding from our discussion with Potomac Edison that there is a significant amount of restudy that would be needed to allow this project to proceed forward to be connected. So it's not the interconnection queue that we see as a major concern. There may be some additional cost that's potential, but I don't know that the applicant has gotten that information from PE at this time. And so our discussions with PE have been somewhat high level, but the indication that in these conversations was that it was a refresh, not a complete redesign. The interconnection queue is one thing. The queue for capacity under the net metering cap is effectively the community solar queue. Presumably, this project would be able to be energized as a community solar project in short order, and that may not have a concern for this particular project in that we don't see hitting the operational cap even within the next 6 months or much longer, as noted in the net metering report from this year. The concern is sort of changing the process or creating waivers that potentially open up additional avenues that were not contemplated by the various stakeholders that have agreed to the and have been abiding by the rules that are in effect for the community solar program and the way the interconnection works. So it's sort of a precedential issue that we're concerned about here. We certainly don't want this project to be delayed unduly, but we think it's important to adhere to the existing rules because we start making piecemeal changes on isolated incidents, and folks may no longer, participate in rulemaking processes with the confidence that what they achieve there is lasting and durable.
Well, certainly on that, we certainly agree. I think the one issue that I ran into a little bit as earlier this year was with regard to the conversion from the pilot CSEG process, and we have a lot of regulations for that. And what I guess some parties and even some of the utilities have started to look at as the more permanent program. And there's been some things that for years we've interpreted, our regulations and our policy have interpreted to say that should not be done or has to be done in a certain way, then Southern doesn't apply anymore. For example, the CSEG-Q. So I think at some point, there might need to be at least a look taken at how the community solar program is going to move forward now that we're in a permanent program. Because we're looking back at the existing regulations, and they were written for the pilot program. And so I don't know if, again, I can't give you exactly what needs to be changed, but this is the second time we've seen this. At least I've seen this. And they've both been in Potomac Edison service territory, and in both cases, Potomac Edison wasn't here. So that's a different issue that we'll have to talk about later. So thank you. That's all I have.
Okay, Commissioner Sussman.
If we were to deny all the waiver requests, then this project would go into the back of the queue, and then would have to request that it be designated a community solar project. Is that how you envision this?
Your Honor, from our understanding, the project would need to apply as a community solar project. It would have to go to Potomac Edison and essentially change the designation in their interconnection application to a community solar project. It is not our understanding that puts them at the back where they're required to do a full redesign of their interconnection, but it may require a refresh that may have some technical changes or additional costs. That is unknown at the time.
Well, I guess, I understood from your filing this first come first serve that the expectation is that they would go to the back of the queue.
So we are speaking also of the project queue in the community solar. There's two separate queues that one can think of. In the community solar queue, those that reach operational status are not held back, but there are certain obligations they have before they can enter that queue. Now that we are in a permanent program, the need for the projects to begin operating is essentially what gets them into the cap. That's the way the law and the regulations currently read. So there is a need to alter their interconnection application if it was originally applied for as an A&M project.
Okay, but what queue are we talking? Are we talking about two queues now or one queue?
There are two queues. I
Okay.
think the waivers are asking for waiving of interconnection regulations as well as a waiver of or reinterpretation of the rule that allows conversion of an existing operating A&M project into a CGIS.
Okay, but I'm actually focused on the queues. So are you saying that there are two queues? There's the interconnection queue and then there's the community solar project queue.
That is
Is
correct.
that what you're saying?
Yes, Your Honor.
And you're suggesting that that this project, if we deny the waiver, they would move to the back of each queue?
It's hard to determine what the back of the queue is because they are accepted into the queue in the order in which when I say the project queues for community solar, those are accepted in the order of application. But once they're in that queue, they are essentially can become operational and leave the queue as soon as they can construct.
Okay. Now, if there's nobody else in the queue, in either queue, then what would be the effect of granting or denying? I mean, it just seems to me, I mean, it sounds like the interconnection studies are already done. What other studies would have to be done in moving this project over to a community solar project?
From our discussions with Potomac Edison, and again at a very high level, it's my understanding that they would restudy the interconnection as a community solar project. And that may have no other change other than there may have been other projects that have interconnected or applied for interconnection at the substation or perhaps on the feeder. Again, we don't have those details. And those projects may end up ahead in terms of the grant of capacity than this particular project if it is essentially refreshing its application.
But if there are no other projects, and this is the only project, and we were to approve the waiver or deny the waiver, either way, it sounds like they would still have to redo the interconnection study at a high level just to make sure there aren't any changes.
No, I believe, Your Honor, if you approve the waiver, they are asking that they do not restudy and do not go through the interconnection process, in a way that refreshes their application. They would simply be permitted to change the notation of this project to community solar, add it to the community solar queue, and as soon as they're able to energize, they would become operational without any restudy.
Okay, so assuming there's nobody else in the queue, then what you're suggesting is the difference between us approving the waiver or not approving the waiver is that there may be a study, and what you're saying is that if we approve the waiver, PE cannot do a study or cannot refresh its study. It's prohibited from doing that.
I don't know that they're prohibited, that they're asking for a waiver, but I think that's a fair way to look at it, in that if you grant the waiver, PE would not require them to pay anything differently or make any additional design changes based on the refresh, because they would not perform one.
So I guess I would just ask PE when you're up if you can address that question about how it would be different and whether you would expect to have to redo a study or to refresh your study if we change the designation. I'm also trying to understand I know that you're concerned about us establishing precedent in this, but I'm trying to understand what that is. This seems like a very unique situation. It's hard for me to imagine a scenario where the facts would be similar to this. But if you can sort of dig a little deeper and try to explain to me why this could establish precedent that would be problematic for the community solar program.
Certainly. Before I begin, I apologize. Potomac Edison has left the building.
No, they're here.
Oh,
yeah.
Sorry, I thought you guys left. You came back. I'm wrong about that.
That's right, yeah.
Okay, good. And is
They're here,
Elvis back also?
That's right, yeah. So they'll be up
Elvis,
next.
I don't know about Elvis. All right, so here's the problem with with this waiver. So this particular regulation is designed specifically not to do anything that affects the cap. So if you have an operating A&M project or another, like a large community solar project somehow, you could convert that to CGIS, but it's already under the cap. And so CGIS and A&M, they're all under the same 3,000 megawatt cap. If you take a project that is not yet counted under that cap and convert it, that's a potential, and in this particular instance, when they're so close to construction, maybe it's like, hey, well, what's really the problem? But there could be a way to apply this, if you establish this precedent, for something that applies as A&M in a manner that, perhaps it wouldn't have been allowed under CGIS. And these particular projects are pilot projects originally, and they were not able to add the fourth project at each site because there was a 6 megawatt cap at the time. That is gone now. And so they can convert this without us running into the co-location issue.
Okay, so if the company, I'm assuming the company is still there. So if the company could address my question about this concern about precedent, that would be very helpful. Okay, that's all I have. Thank you.
Okay, so before I turn to the company, let me actually go to Potomac Edison and let them clear up to the extent they can some of these questions that all of us have been asking. So.
Good afternoon. Again, Jessica Reba. I have Mark Zucco with me as well on this issue. I think Mr. Vanderheyden has done an excellent job of summarizing the situation from Potomac Edison's perspective. He's correct that if the projects were to refile, we would not require an entire new interconnection study because that work has already been done. We would refresh that study and look at it again, but we would not expect that to take anywhere near the amount of time as a brand new project. I think that was the main question, but if I missed others.
Well, okay, so let's start. Anybody else have Commissioner McLean?
I think one of the questions is the queue. What does it like if they have to go to the back of the line? What does your queue look like?
Our queue is very full. But for purposes, and Mark can correct me if I'm wrong, but when you're looking at a project, what's relevant is if there are other projects looking to interconnect at that same substation or feeder. I believe that is not the case with these projects, so the queue is not an issue.
Okay, excellent. Thank you, ma'am.
Commissioner Litton.
Yeah, thank you.
No, you go ahead. So, yeah.
Oh, me?
Yeah, you.
Okay. Good morning again, or afternoon again. And I am glad you're here.
I've been here the whole time, Commissioner Linton, I swear.
Well, I guess I should say I'm glad
that.
You stayed.
You can feel the excitement in the voice.
I'll just say that. I'll say it that way. I'm glad you stayed. We've heard some suggestion that there may be an additional need for a refresh for the interconnection study. Are there any costs or fees that apply to that?
So I think if they reapply, now that we have, you recently just approved our application fees. So I think if they reapply, we would treat it as a new application in that regard, and they'd have an application fee to pay.
Okay. Then that's it? There wouldn't be anything else?
I mean, I don't think until we did the refresh, we could say with 100% certainty that there wouldn't be costs that weren't there before, but it's my understanding that that's our expectation.
Okay, so I don't believe, and you can certainly correct me if I'm wrong, but I don't believe the company did file anything in response to this particular item on our docket. So I suspect, and I can respect, that the company may not take positions on these types of filings. But I guess I'll ask it a different way. Are there any issues here that you think we need to be concerned about for purposes of how our final choice might impact Potomac Edison's queue, need to deal with these kind of conversions, et cetera?
Yeah, thanks for the question. Staff did reach out to us, and we're happy to work with them as they are evaluating these issues in terms of, the engineering and how it affects the queue and our distribution system. In terms of the larger policy questions that you have in front of you, I'll offer that from my perspective, I think staff got it right. But you're right that we haven't taken hard positions on these types of questions.
Okay, so at least for this particular one, I ask a little more directly. For purposes of trying to convert an A&M to a CSEG, are there any issues that you think the commission needs to be aware of?
I think it's the ones that Mr. Vanderheyden has already stated, right? In terms of setting a precedent, I don't know what that would look like, right? Sitting here today, how many other project developers might try to file something next week if you grant this one, right? I honestly don't know, but I think that concern is the right one to have.
Okay. All right, I just have one other question. And you mentioned earlier that your queue was full, but it depends on where it's connecting from at a substation level.
I say it's never full. I just say that to say we have a lot of projects in our queue.
Okay. So I'm trying to understand what when you say a lot of projects, are you talking about like hundreds, tens?
Hundreds.
Hundreds. Okay. All right, and that's of course spread out across the service territory.
Correct.
But in this particular location, at least as far as you know today, there isn't a queue-related issue.
That is my understanding. Yes. Yep.
Okay. Thank you. Thank you, Mr. Chairman.
Okay, so let me go to Commissioner Sussman, and I'll come back to you.
Okay, so in terms of the refresher of the study, would that occur regardless of whether we approve the waiver or not? Would you still, if we were to approve the waiver and it becomes a community solar project, would you still need to do some kind of refresher?
No.
And why is that the case? It's the same. It's the same project.
I'm gonna let Mr. Zuka take this one for you.
Good afternoon, Commissioner Suchman, Commissioners. This is something that's a little new, so just trying to figure out what our process would be here. This project has been in our queue for a while. We've been working with the developer. It has nearly come to the part where it's in service. We've done a lot of the technical work, a lot of the interconnection work in the field. So at this point, even though our study is several years old, we're not going to refresh it. This thing is moving, it's going into service. But if it were to withdraw from the interconnection queue, which is what's being suggested here, and then reapply as a new project, we would be required, as Ms. Rabus mentioned, to charge interconnection processing fees, and we would have to redo a study. We're not looking to do new work here at Potomac Edison. As Ms. Raber mentioned, we have lots of stuff in our queue to do. So to the effect we have this study technically done, we're going to ask our engineers, take another look at it. Is anything changed? We don't believe that there has, but just make sure that there is, that it is still correct, and then basically reissue it as a new completed study. That's how we feel we would have to process this if it withdraws and renews. But if it doesn't, then this thing is ready to go in service.
Okay, so Mr. Zuka, if they were to withdraw and resubmit, how many projects would be ahead of them in the queue?
So again, I think of Potomac Edison's interconnection queue from the first net metering project we got to the last. I mean, we're at 4,000 right now, something like that. So if they might be 2,000 today, they withdraw, they reapply, they're now 4,001. So there now may be thousands more projects in between where they were and where they're at. But practically, our engineers are looking at a specific location. These things are connecting to specific feeders out in Garrett County that come from a specific substation. So all those other thousands of projects don't actually matter to the engineer because they don't affect the electrical connection of this generator. So
Okay.
that's what we
Now-
mean when, sorry.
Okay, but are you concerned about the reliability of your system if we were to approve the waiver and there wouldn't be a refresher of the study?
No.
Okay. And then I have to say that it seems like a lot more work and a lot of wasted effort if we follow this the suggestion of staff, and we'll still get to the same place. It'll just take longer for the project to come on board. But that's all I have. Thank you.
Commissioner Barbie.
Well, I think Mr. Zuka answered the fundamentals of my question. It almost seems, well, let me state it this way. It almost seems as if in your queuing process, each feeder is sort of a mini queue, in effect, correct?
I would say that's correct, yes.
Okay. Well, let me ask another question. I don't ever remember, I have a really bad memory, so that could be the reason, but I don't remember an A&M project being converted to CGIS during the 2 years I've been here. Has that happened before? Does it happen frequently?
I believe this is the first such request, at least for Potomac Edison's territory.
Okay. Okay, I believe all the questions I had have been answered, so I'll leave it there, Mr. Chairman.
Okay. Actually, before you guys go, so this, you said part of the process is the uniqueness of this site. And so if I remember right, this is an abandoned coal mine, so it's out in that part of Garrett County where there's literally like no houses around it and things like that. So I take it that part of your service territory, there's not a whole lot of people looking to hook up anything, correct?
Do you mean as far as solar facilities
Or both? I mean, just because, I mean, I'm sort of familiar with that part of Garrett County, and those abandoned coal mine sites are not, you know, prime properties for lots of stuff other than these.
Yeah, I mean, obviously, we can't comment on what the land is being used for. I mean, there are areas of Garrett County that have a lot of development, especially around Deep Creek
Right,
Lake.
yeah, around the lake,
And
sure.
we do see a lot of solar development in Garrett County.
Okay, all right. Okay, so let me finally go to the company. And actually, one thing you might want to, you may address this anyway, but we have been sort of dancing around this issue about whether or not your particular situation is sort of unique enough that it really could be considered to be a one-off, or is there some danger that giving you what you want does create a precedent that, you know, invites others to try the same path, so.
Understood. Eric Wallace with law firm Green Herlocker on behalf of Amoresco, and you know, there's been a lot of discussion on this matter so far this morning. So I'll jump straight to it. You know, as a threshold question, OPC had asked about, in our filing, we had marked certain information confidential about the offtake customer and why we did that. And the reason was because we wanted to go ahead and get it filed. We were awaiting confirmation that we could disclose the customer's information publicly. We hadn't gotten that yet, and so we went ahead and filed it that way. But, you know, I think the issues before the commission can be addressed without getting into those confidential aspects of the filing. And certainly in the future, you know, we intend to, you know, make sure we have everything as marked as publicly as possible in these matters. But getting to the substance of the issues before the commission here, you know, this is a cluster of projects that applied, you know, it's 3 different sites. As staff laid out, there are 3 2-megawatt community solar projects and 1 2-megawatt net metering project on each of the sites. So we're talking about 24 megawatts altogether. Amoresco applied for interconnection with Potomac Edison back in 2022, has been working through the study process with Potomac Edison for all of these projects since that time. We now have signed interconnection agreements. Amoresco has paid for Potomac Edison to do the construction work necessary to do the interconnection attachment facilities and the upgrades that are necessary to the distribution system to interconnect these facilities. All of that work is winding up. The facilities themselves have been constructed. There's one of the sites, the Pee Wee Road site, they have the racking and the piling and a lot of the equipment installed. There are still some panels yet to be installed. But the bottom line is these are fully studied, you know, nearly fully built projects that are ready to come online. And had we been able to get this approved a few weeks ago, 2 of the sites were expected to be online by the end of the year. That's now rolled into the first part of the first quarter. But you know, it's essential that we get resolution on, the status of these projects with respect to their program, A&M or community solar, as well as their interconnection queue positions. Well north of $50 million has been invested in these projects over these many years, including substantial interconnection costs and all of the development and construction costs for the facilities themselves. If the commission were to adopt staff's position, it would require the projects to be withdrawn, 3 of the projects, 6 megawatts, to be withdrawn from the queue, have their interconnection agreements terminated, and go back into the queue again where they started out in April of 2022, with the hope that there's a quick refresh and we can get back to where we are now relatively quickly, hopefully by at some point mid next year, right? But we're back in the same place. There's nobody behind us that benefits. Nobody benefits at all if this request is rejected and if these projects are forced to withdraw and reapply as staff has recommended. I have sort of 2 main points that I want to address this afternoon with the commission. The first is, there's nothing in Potomac Edison's tariff, in Public Utilities Article 7-306, in 7-3-306.3, which is the 306 is net metering, 306.3 is the aggregate net metering provision, or in the commission's regulations that would prohibit the commission from doing what we're requesting, right? So ultimately, this is a policy, and nothing in staff's buck sheet suggests that the commission can't do what we're asking. Ultimately, this is a policy decision of, does the commission want to stall these projects out, have them start over, inject risk into the projects that are ready to come online in order to satisfy, staff's concerns about, procedural requirements and their perceived preferred path for these projects. Alternatively, if our request is approved, which the commission has broad discretion to do, either by finding that it's an A&M project that converts, or by waiving the CSEGs and interconnection provisions that would otherwise require that, that would allow us to move immediately under the community solar program, get out there and get finalized subscriptions, and bring these projects online as soon as possible. That's what we're seeking to do, and we think that that is consistent with clear Maryland and commission policy to bring as much in-state capacity online as quickly as possible, particularly on brownfield sites. In the recent PC 73 decision, the commission took several steps to remove administrative burdens and expedite bringing community solar projects like these online, including directing an emergency rulemaking to expedite interconnection and reduce administrative processes that delay clean energy projects. So this is a perfect example of an opportunity for the commission to exercise its discretion to facilitate bringing projects online consistent with the policy reflected in the PC 73 proceeding. And then on Friday, Governor Moore issued an executive order to accelerate the deployment of new energy systems by establishing the Maryland Energy Site Readiness Initiative to vet land projects for new energy projects, prioritizing disturbed lands like brownfields and industrial zones over green space. These SWATN projects are exactly the kinds of projects the governor is pushing to accelerate, clean energy projects on brownfields that will serve low and moderate income customers, offering monthly bill savings that will help make energy more affordable for thousands of customers. Despite staff's opposition, now is the time for the commission to take decisive action to approve this conversion request and help avoid delays to get these projects online as quickly as possible. As we detailed in our filing, the commission has broad authority to grant this request either by finding that these are existing aggregate net metering facilities. They have been, if you go out and look at the sites, we have pictures here. Construction is underway. It's nearly completed at most of the sites. They physically exist out there on those sites in Garrett County. To the extent that the commission is not comfortable finding that these are existing projects, there's also the option of a good cause waiver under COMAR 2050-0906 and 2050-0105 rather, and 2062-0104 with respect to the interconnection regulations and the community solar regulations respectively. That would facilitate the result that we're seeking as well. Staff does not dispute the commission's authority to grant the waiver requests. Rather, staff simply opposes them. Staff's recommendation, as I mentioned, would require going to the beginning of the interconnection process. It would also depart from clear direct precedent allowing aggregate net metering facilities on leased property. One of the sub-issues within staff's buck sheet is this question about whether a municipality that's eligible for net metering can lease a property, build a project there, and then use that for net metering. That was a question the Commission answered in 2018 in the One Energy Blue Star decision, where the Commission said, yes, leased property is eligible for aggregate net metering. That becomes the premises. Just like if I were to go lease an apartment, I could establish service with Potomac Edison based on that lease. So too can a municipality lease a property, build a net metering facility, and they then allocate all of the output of that facility to their other accounts, right? So that's the rule. You can only use the output of your facility for your other accounts. And that's exactly the way that this project was structured, consistent with that clear precedent from the One Energy Blue Star case. Staff offers no principal distinction between this case and the One Energy decision, much less a compelling distinction that might support such a radical departure that would halt these clean energy projects in their tracks right before coming online. Such a decision would be arbitrary, capricious, and raise appealable due process issues. However, the practical issues are much more important and significant than the legal issues here. Granting staff's request will impose arbitrary administrative burdens to stop 6 megawatts from coming online. Rejecting the conversion request and finding that these Swanton projects are ineligible for aggregate net metering would be contrary to Maryland Commission policy supporting distribution-connected solar projects on brownfield sites. It would not benefit anyone, but it would send a deafening message from the Commission to Ameresco and to other clean energy developers that Maryland no longer welcomes private investment in clean energy development on brownfield sites to serve low and moderate income customers. This is a huge deal for Ameresco. Second, staff's primary objection to the conversion is their argument that these projects are not eligible for aggregate net metering to begin with. These projects fully comply with all of the statutory Commission regulation and Potomac Edison tariff requirements. From the beginning, Ameresco has followed the applicable tariff processes, coordinated with Potomac Edison throughout the process. We even came before the Commission and staff late last year with a issue regarding these sites. That issue involved whether a CPCN would be required under the 14 megawatt cap. The Commission found that it was not. Staff took a close look at these projects as part of that process. We had a lengthy discussion before the Commission on that matter. Nobody raised any concerns about the fact that 3 of the projects were net metering. So it's only at this late stage now that we have this objection from staff. Practically, to be an eligible customer generator for net metering, there's 3 core requirements. First, it has to be located on the customer's premises or contiguous property. That is the premises issue from One Energy Blue Star that I mentioned earlier, and a lease satisfies that requirement, which is what we have in this case. Second, it has to be interconnected and operated in parallel with the electric company's transmission and distribution facilities. That is exactly what this project is doing as well. And third, it has to be intended primarily to offset all or part of the customer's own electricity requirements. That is exactly what this project is doing. All of the output is allocated to other accounts of this municipal customer. Finally, you can participate in net metering by satisfying those requirements. You also have additional requirements to do the aggregate net metering model, right? So if it's not, your rooftop facility serving one account, and that requires that you be one of the eligible customer types. A municipality is included, and that's what we have in this case. Code section 7-306, our net metering provision, dates back to 1998. It's been updated many times since then to continue to expand and improve opportunities for customers to participate in net metering. And importantly, in 2023, with Chapter 460, the General Assembly added 7-306.3, titled Meter Aggregation, which built upon the Commission's existing regulations in COMAR 2050-1007, allowing for meter aggregation. At the same time, the Commission added those provisions to the statute in 2023. The Commission also updated the CPCN statute, Public Utilities Article 7-207, to add language excluding, excluding co-located A&M facilities from the requirement to obtain a CPCN. Again, making configurations like this more available with less processes before the commission in terms of the CPCN. The One Energy Blue Star case is critical in this matter on the A&M question. That was issued on May 31st, 2018 in case 9387. The commission found that leased premises qualify for net metering, and that decision also included a separate issue prohibiting co-location because those A&M facilities shared a same utility account number. The General Assembly has since gone back and amended 7-306 to respond to that issue. Notably, in the One Energy Blue Star case, the commission also directed staff to review PUA 7-306 and, quote, propose regulations that clarify the premises and co-location issues raised in that case. In the 7.5 years since the Blue Star decision, staff has not proposed changes to the commission's regulations to address the premises issue. However, PUA 7-306 has been amended several times in 2021, 2022, 2023, 2024, and 2025. None of those legislative changes modified the commission's decision allowing leased premises for net metering. Rather, they continue to expand upon the net metering framework. And in 2023, the General Assembly passed HB 460, overturning the commission's co-location restriction in that Blue Star case, allowing co-located A&M projects on the same site. The bottom line is that the commission's decision to allow municipalities to lease premises and build A&M facilities on those premises stands as directly applicable precedent. It would be arbitrary for the commission to overturn that decision now, to reject Ameresco's conversion request, and go further to prohibit the A&M projects from moving forward under their existing interconnection agreements. Regulatory consistency and predictability are critical to enable long-term investments in clean energy projects in Maryland. Ameresco and its municipal customer reasonably relied on the commission's precedent interpreting Public Utilities Article Section 7-306 and COMAR 2050-10 to develop these A&M projects. To the extent the commission or staff are inclined to revisit the premises issue from the Blue Star case, a prospective, generally applicable rulemaking process would be appropriate to consider potential changes. However, the commission should not reconsider leased premises retroactively without notice on a project-specific basis. For all those reasons, Ameresco maintains its request and asks the commission to proceed with granting the conversion requests, enabling these projects to come online as soon as possible. And there's one additional item, Chairman, you'd asked that I address, which is
Why this isn't a precedent.
what the precedent is. Yes. So, as we addressed in our initial filing, this is a unique situation. These projects applied back in 2022. At the time, the law prohibited. We had sites that could accommodate 4 projects. The law prohibited co-location of more than 3. Right. So that's why they did 3 megawatts of community solar and 1 of aggregate net metering. In the intervening period, while these projects have been in process, HB 908 came out in 2023, got rid of that co-location restriction, and at the same time, we've had, with the transition to the permanent program and the development of consolidated billing for community solar, we've made a lot of improvements to the community solar program, and so Ameresco and its customer decided that would work better for these projects. And now that there's no longer a statutory or regulatory prohibition on having these all be community solar, they would rather do that. And that's what prompted us to make this filing. Those changes are, have been very much in process throughout the year, and the commission heard the tariffs at the beginning of this administrative meeting approving the consolidated billing mechanism. So I think this is absolutely a unique issue. The commission has not heard this before, as staff mentioned in its buck sheet. This is a new issue. I can't imagine that someone else would set up a project to do this. It wouldn't make sense. You would decide from the beginning, these are long-term projects, long-term investments. Nobody would set out from the beginning, in my experience, with a plan to change things up right at the end. The only reason that we've come in with this request is because of the unique characteristics and changes in law that have happened over the years and the path forward that is going to allow these projects to become community solar projects. And that will also mean that 40% of their capacity is available for low and moderate income customers that will provide them monthly bill savings for 25, 30, or more years to come. So there's a long-term benefit for those low income customers as a result of this conversion. And with that, I'm happy to answer any additional questions the commissioners may have.
Mr. Barbay. Thank you, Mr. Chairman. Okay. I may have misheard something that you said, so please clarify this for me. But I think I heard you say something to the effect that if we did not grant these waivers, this would somehow kill these projects. Did I mishear that?
But it would be devastating for the projects because they have gone through the study process. They have interconnection agreements in hand.
Okay.
Based on those, confirmed contractual rights, they have gone out and financed construction of these multi-million-dollar major infrastructure projects, these community solar projects, right? And what we would be doing is taking away that interconnection agreement with the hope that everything goes well when we reapply.
You're saying that by not granting the waiver, we would be taking away the interconnection agreement that they already have?
That's what staff is requesting here, that the commission require these projects to reapply because staff is arguing that they're not actually eligible for the A&M program that they are currently in, have been studied for and are sitting awaiting commercial operation for, right? So they're not just saying, keep the status quo and don't approve the request. Staff took it a step further to say, and find that they're not eligible for the aggregate net metering program. So the only path forward would be to reapply under the community solar program because these aren't eligible as aggregate net metering according to staff. That's my big concern here with what they're recommending. And if I'm reading that wrong,
Could I ask staff if that's a fair interpretation of?
All right. Well, yeah, I get. Just on this one point.
Yeah, on this one point.
So on the point of, we believe they are not, based on the PE tariff, eligible for A&M. So these projects should not be treated as if they are A&M projects for the purpose of converting. That is our position.
Okay.
If you treat them, I don't know if it creates a precedent. I mean, our attorneys, I'm sure, could figure that out. If you allow this waiver, does that mean that every time, and the issue is not leasing, like you can lease property. The issue is, do you have a load there? If you look at the PE tariff, and I have it here if you want me to read it, it allows a direct connection. So if you have a 2 megawatt facility, you connect it directly to distribution feeder. A&M is like behind the meter net metering. That's how it's described in the tariff. That's how it's written up. We allowed for convenience and technical efficiency. Hey, make a direct connection. If you have a 2 megawatt facility and you have a 300 kilowatt transformer on your school, you're not going to be able to run that 2 megawatts back through the 300 kilowatts. So hey, let's make a direct connection. It's simpler, it's safer, it makes sense. That I think has been run with in some circumstances. Folks, that means I can lease something where we have no load, and we can put a facility there and then lease it and then say the load on the array is the existing load. I mean, if this waiver is granted, folks might think that that's something they can do going forward, but most of the tariffs, not all the tariffs, and this PE in particular, I know BG&E's got it, they allow direct connection, but it's got to be for when you have an existing facility there, not a trivial one. You can't set a street light and say there's my load. It is not intended to change this from a behind-the-meter arrangement to a form of virtual net metering that's akin to community solar, where you can just build a facility. So I think that's really, that hinges on our concern. We'd love to get these guys up and running as fast as possible. Seems like there's some opportunity with PE to do that, but the concern is that you're sort of changing this. And it's fair to bring up the Blue Star case, so that was in a different utility over in Choptank, I believe. Their tariff may not have addressed this the same way. And we have had rulemakings in the aggregate net metering area since then, and I think staff may have proposed regulations that also did not get off the ground. I don't know the exact, it's going back a while. So, I mean, I would agree we should probably have regs on this, and there should be a clear policy. But this is not, we're not denying it because they're leasing it. We're denying it because there isn't any load there, and as a result, it's not aggregate net metering. And there may be another way to work with PE.
I think I understand the crux of the situation now. Thank you. Thank you, Mr. Chairman.
Mr. McLean.
Good afternoon, sir. What is there a significance in terms of the timing of your request? I mean, why didn't you make this request months ago? Or are you looking, is this has to be a 2025 decision on this, sir?
Yeah, it's a good question, and the timing is important. So, the reason that we didn't apply earlier was that, things have been in flight with consolidated billing and the changes that were coming forward, and the recent utility tariff proposals memorializing the changes with consolidated billing for community solar. That was something that Ameresco and its customer were tracking, but we needed to see how that was going to play out before they could make a decision to go ahead and do this. And so that was why we didn't apply in April, or earlier, because we wanted to confirm that things were going to work out the way that we were hoping it would, that would make this a more appealing option for this customer going forward. So, and the reason that it's important that we get a decision on this is, these projects are ready to come online very soon, right? Had we had a decision a few weeks ago, the Ameresco team is confident that 2 of these sites would have been online by now, right? So a total of 16 megawatts across those 2 sites, and the third site is ready to come online in the first quarter. Given where things stand, that's going to spill into early next year. But we really need to have, clarity from the commission that we can move forward so that we can go out and get the subscriptions lined up for these sites, get those submitted to Potomac Edison. I think they have to be in 30 days in advance of the billing period where the project comes online, and get all those pieces in place so that everything can move forward, along with all of the internal coordination and financing structures. I mean, these are significant projects that have a number of different parties involved from a financing perspective, and they need certainty about the status so that these projects can continue to be funded and move forward into commercial operations. So,
Thank you, sir. And 16 megawatts, those are ready to go?
yeah,
They're finished construction.
those have finished construction. Potomac Edison is, I think, working on some final kind of testing and configuration on the attachment facilities that are used, that are connecting them into the distribution system. But the facilities themselves are fully constructed. If you go there, they are ready to come online and be energized. So it's just a matter of those kind of final closeout processes with Potomac Edison to get them online.
Okay, so is it fair to say that those 2 are probably more existing than the third?
The difference is that the third, it has much of the equipment there. I think that the rest of the panels will be going in like over the next couple of weeks, or maybe first week in January that'll be done. There's significant equipment there, but they are not fully completed and constructed in the way that the other 2 sites are.
Okay, thank you, sir.
Commissioner Suchman.
So, Mr. Wallace, in the staff's buck sheet, they're arguing that your client, those 3 arrays should not have been AHEMs to begin with because they're not located on a customer's premises. And just to be clear, all 3 sites, right? So there are 3 sites.
Yep.
And all 3 sites, Frederick, which would have been the customer, is leasing the land, correct?
That's right. They've consistent with the Blue Star decision referenced in footnote 10 on page 10 of staff's buck sheet. These are leased sites where they have a property interest.
Okay.
On that lease.
All right. That's all I have. Thank you.
Yep.
Commissioner Linton.
Thank you, Mr. Chairman. So, just to follow up on Commissioner Suchman's question, it was my understanding from my questions earlier to staff, is that your client submitted your applications for these projects as A&M projects, and it's your position that that's what they've always been?
Correct.
Okay.
And
Are they
submitted
virtual?
under-
I'm sorry, go ahead.
But they're submitted under the A&M rider. There's a form that you submit along with your interconnection agreement for an A&M projects, and that's what they submitted to Potomac Edison, and that's how they've been kind of treated as between Potomac Edison and Ameresco for these several years now.
Okay, so just based on what I've been hearing from staff today and from what I've read, it sounds as though staff is concerned that these were not necessarily A&M projects, but, and I don't think this is a term, but I'm going to use it for right now. They're more like virtual A&Ms, so that you're not necessarily offsetting or your behind-the-meter solution is not necessarily interconnected to operate like an A&M project. I mean, is that what is happening here, or is there some feature about this project that doesn't match what typically would be an A&M project?
That's a typical structure. So there's two different options for meter aggregation under the Commission's regulations. One is physical, where it's on site and you're physically aggregating meters. There's also virtual, and that's a term in the Commission's regulations for situations like this where you have, disparate sites and so you are coordinating with the utility, providing them a list of accounts as part of your A&M submission to say, we want to take the generation from this account and we want to allocate it to this other series of accounts, and they do that on a waterfall each month. And so they go, once the first account is fully allocated, they move on to the next and move through them until all of the generation output for that month is fully allocated to that same customer entity's other accounts. And that can be done virtually, or that can be done physically under the Commission's regulations.
Okay, and so the customer here is a customer large enough that we have that scenario set up?
That's right.
Okay. I don't think we've said who the customer is. I have not.
It's okay. We have permission, and
Oh, you do?
Commissioner
Okay.
mentioned it. City of Frederick is the municipal customer here.
Okay, it's a municipal, okay. Thank you for that. So my other question has to do with the company's or the developer's willingness to move forward as a CSEC. You haven't been that up until this point. So there are certain requirements on CSEGs in terms of interacting with customers and other requirements in not only in the company's tariff but also in our regulations. Are there any issues with the developer moving forward under those same requirements? Are they prepared to do that?
That's right. So at each of the sites, there are already 3 CSEGs projects. And so this is simply what we've requested in the application is, and those are all have subscriber organizations that have been certificated by the Commission.
Right.
All we're asking is that the Commission add these projects to those existing subscriber organization certifications, and then those entities will go subscribe the projects, and they're prepared to do that. That is, that's part of the plan here for this conversion request.
So you're basically just adding, you're adding a little more capacity to the existing ones that you have already.
Exactly.
Okay. That was all I had. Thank you, Mr. Chairman. Thank you.
All right, so I take it that the earlier discussion with Potomac Edison about the interconnection queue and sort of the nuances of it, that even though you be, quote, at the back of the line, you may not necessarily be at the back of the line just because it depends on where the unique location of where your system's going to plug in. It kind of allows you to jump ahead of people, is not enough assurance for you to have us deny these waiver requests.
It's a concern because we don't know what will happen, right? I mean, hopefully they will do a quick refresh and we'll be able to get back to re-signing our interconnection agreement and nothing will change, right? But today we have a signed interconnection agreement where we've already spent millions of dollars building out significant interconnection equipment and distribution upgrades to accommodate these projects. And if that causes a delay, or if that because they have to procure new equipment, or there's something else that comes along, if something else has changed, nearby on the grid that has some sort of an impact on these projects as a result of that restudy, that creates risk that is unacceptable to my client. And it also means that Potomac Edison is spending its time restudying projects that have already been studied, have already been, their facilities have been built and they're ready to come online safely and reliably. So, going back and redoing that is just a, inefficient use of time and resources for both Ameresco and the customers that are waiting to receive these bill credits, and also for Potomac Edison that could be focusing on what sounds like many other projects in its queue that its engineers could be focusing on instead.
All right, so I think my preference is actually to take this under advisement, just because I want to, figure out if there is a path forward that gives you what you want, but doesn't necessarily create a precedent that's going to create us problems down the road. So why don't we?
Mr. Chairman, the issue with, if there's a possibility that the commission could make a decision today, it would be critical to my client's ability to, continue with this project, have the financing certainty that it needs to proceed. They're also working on a number of other projects around the state. I understand that there are some nuanced issues here, but it's, at the end of the day, the commission has the authority to grant this request. No other projects are affected by it. And it's simply, a waiver that enables this project to come forward.
All right, so let me do this. We're going to take a brief recess and discuss this right now and see what we can come up with. So,
Thank you.
Okay, so I make a motion that we waive Comar regulations 20.50.09.06B and D and 20.62.03.03 and 20.62.0304 for good cause. Commissioner McLean.
Aye.
Commissioner Linton.
Aye.
Commissioner Suchman.
Aye.
Commissioner Barbat.
Aye.
I vote aye.
Thank you.
Right. Items number 27 and 28 are requests for airport exemptions from Ward 3 LLC and Ward 2 LLC.
Good afternoon, Chair and Commissioners. Harrison Chair on behalf of staff. Ward 2 and Ward 3 filed on October 27, 2025, requests seeking recognition under the At Airports exemption to the Community Solar Program's co-location requirements found under PUA 7-306.2 D13 and Comar 20620308. Co-location of community solar projects is capped by statute to 5 megawatts total unless a qualifying exemption is implemented. The Ward community solar projects are proposed to be 3 5-megawatt projects totaling 15 megawatts of capacity. The 3 projects are proposed to be located on 2 adjoining parcels. The project parcels are private land that border the Wacomico County Airport, as well as 2 different community solar projects. The 2 bordering projects each total 10 megawatts in capacity for a total of 20 megawatts. The 2 bordering projects were each approved into the program before the Ward projects initially applied. To staff's knowledge, this is the first instance of an applicant attempting to use the At Airports exemption. The full statutory reading of the exemption states that the prohibition under subparagraph I, which establishes the 5 megawatt co-location cap, does not apply to projects constructed at airports. Airports are one of the 8 locations listed in the statute where co-location is uncapped. Some of these other areas include rooftops, brownfields, and areas zoned for industrial use. The projects assert that at airports should be interpreted to mean near airports, and because the proposed parcels border the airport property, they should qualify for the co-location exemption. Staff has concerns with interpreting the statutory language this broadly. If the Commission were to interpret at airports to mean near airports, the question of how near would immediately arise. Staff concludes that it is premature to accept this interpretation of the ambiguous phrase at airports. As this is a matter of first impression in analyzing this particular co-location exemption, staff recommends that unless and until a rulemaking take place, at airports should not be interpreted any more broadly than meaning areas that are under the direct ownership or control of an airport. Staff believes that the Commission should proceed cautiously in setting precedent for future applicants that may also aim to use this exemption. Accepting Matrix's interpretation of the at airports exemption, absent a rulemaking, would exclude relevant stakeholder input and public comments, as well as the publication and notice period in the Maryland Register that are necessary components required by the Maryland Administrative Procedures Act. In addition, a precedent for at airports exemption should not be determined at an administrative meeting that does not include the appropriate opportunity for comment from relevant stakeholders. Maryland case law supports this type of determination taking place during a rulemaking. In CBS Inc. v. Comptroller of Treasury, the Maryland Court of Appeals determined when a policy of general application embodied in or represented by a rule is changed to a different policy of general application, the change must be accomplished by rulemaking. In Delmarva Power and Light v. Public Service Commission of Maryland, the Maryland Court of Special Appeals applied this principle directly to the Maryland Public Service Commission. Here, the Commission would be changing the application of the plain text meaning of at airports to something more expansive. For these reasons, staff recommends that the Commission deny the requests of Ward 2 and Ward 3. Thank you, and I'm available for questions.
Okay, any questions for staff? Actually, I have one question. So, has the county, Wycomico County, offered any opinion about this particular solar facility that you're aware of?
No, staff is not aware of any opinion from the county on this.
Okay. All right, so we'll go to the applicant.
Thank you, Chair Hoover, Commissioners. David Bugelmans, this time on behalf of Matrix Solar, the two SO applicants, Ward 2 LLC and Ward 3 LLC. I'm also joined today to my left by Mr. Michael Dowd from Matrix Solar. Matrix Solar is not asking for the Commission to waive anything, simply asking the Commission to apply the exemption the General Assembly already put into place. So first on the waiver point, staff is correct in its buck sheet. The Commission can't waive a statute without an express provision allowing it to do so. But we're not asking the Commission to waive anything. The statute says co-location. The co-location limitation does not apply to projects constructed at airports, and COMAR adopted by the Commission mirrors that exception. Matrix is not asking the Commission to waive anything. Matrix is simply asking the Commission to apply the existing law that's on the books. On that point, staff proposes that the term at airport should be read as owned or controlled by the airport. Respectfully, this is not what the statute or COMAR says. The General Assembly meant on airport-owned property and knew how to say it, but it did not do that. The Commission did also did not say that when it adopted the regulations for the permanent program. The General Assembly chose the word at. In everyday language, property that directly borders an airport is property at the airport. The term at the airport, in general sense, often includes nearby areas that people associate with the airport, even if they're technically off airport property. One important factor here is these parcels are in Wacomico County's airport overlay zone, which recognizes generally that airport areas are not just the parcels where the actual airport's located, but the area around it. This is an officially recognized airport designation by the county, similar to the same concept around BWI and Anne Arundel, if you're familiar with that. With respect to the point that Matrix is asking the Commission to adopt an unbounded standard, that is not what we are asking the Commission. By approving these SO applications, the Commission at most would be setting a precedent that a project is at an airport when it's located on property that directly abuts airport property. It's not vague, and it's a very bright line, and it prevents the slippery slope that staff is concerned about, and it gives real meaning to the exemption without rewriting it. Third, staff suggests that because this is an issue of first impression, the Commission must go through a rulemaking before it can interpret the term at airports. Respectfully, agencies interpret and apply existing statutory and regulatory terms in adjudications every day. This exemption already exists. You're not changing COMAR. You're not creating a new category. We're simply asking the Commission to do what it does in many cases, including on many items before you previously on this agenda, which is apply an existing legal standard to a specific set of facts. I would also note that staff's proposal is not a do-nothing neutral position. Limiting this language to, quote, owned or controlled by the airport would be a new restriction that is not in the text. It would constrain the exemption for every future applicant. So by that measure, a rulemaking would also be necessary to support staff's preferred interpretation. Finally, staff raises the concern about nearby projects and aggregation. We hear and appreciate that concern, but the answer is as simple as the interpretation I just described. If the Commission ties at airports direct adjacency to airport property that does not open the door to unlimited development, is geographically bounded and simple for staff to administer for future SO applications that may arise for adjacent projects. For these reasons, we respectfully request the Commission approve these two SO applications on the basis that they are at airports by virtue of their location immediately adjacent to an airport. We appreciate your consideration today. I know it's been a long day, and we appreciate it. Happy to answer any questions.
Okay, Commissioner Barbe.
So, if I own a parking lot near BWI Airport, it's clearly near the airport, might even be next to the airport. Do you interpret that as being at the airport?
What we're proposing is a property that's directly adjacent to the airport.
Well, let's say, I own it and it's directly adjacent to the airport, you say that's at the airport.
Yes.
Okay.
Mr. McLean.
Good afternoon, sir. By saying it's immediately adjacent to the airport equals at the airport, aren't you essentially doing the same thing staff is? Saying it's got to be, you're adding text to the statute?
Well, we're not adding text to the statute. My point with respect to that issue is that it's staff's position is effectively the commission can't grant this request because a rulemaking is needed. That's our position is a rulemaking is not needed, but if
The
you were to
last
adopt that
thing-
interpretation, you also could interpret staff's preferred interpretation.
I think the last thing anyone wants is a
Correct.
rulemaking on the word "at." But you also relied on the airport zone overlay.
Yes.
So couldn't I make an argument if I've got a property that's next to you, but it's not contiguous to the airport, but I'm in the zone, that I'm still at the airport?
Somebody could make that argument. That's not the argument we're making today. Obviously, if that were to happen and the commission had approved this request, stand for the principle adjacent, you're good to go. Anything further than that, I would assume staff would deny it or require another hearing like this. So I don't think it's opening the door to that, but somebody could come in and say that. I think that is an argument that could be made.
Okay, thank you, sir.
Commissioner Suchman.
So I'm one to look at statutes and take the word of the statute. And at seems to be specific to a location. I mean, if you look at all of the other sort of provisions on the rooftop of buildings, it's not on or near the rooftop of buildings. So each of them all have prepositions. So on, in, on, over, on, at, on. So what I'm suggesting is as I read it, the General Assembly was pretty clear about what they wanted. If they wanted property that was adjacent, they would have added the words "or adjacent to," at or adjacent to airports. If we read it any other way, we would be inserting language in that it doesn't seem to me that the General Assembly had any intention of doing. I suppose that if that was their intention, then maybe in the next session they can clarify that language. But you're asking us to read into what seems to be pretty clear language. That's the preposition, seems to be directed at a particular place. You're asking us to read beyond that, and I don't see that there's any language among the other exemptions that would suggest that the General Assembly had any interest in going beyond what was specifically put in there. And I think actually it's important for us not to read into this because these are exceptions. Otherwise, then we can read into all of these exceptions so that the exception swallows the rule. I guess maybe that's not so much a question as a statement that Mr. Bugelman's, your proposal doesn't make any sense to me. And maybe you can sort of explain why I'm wrong.
Well, I think my comments were my point, which is the idea that in common sense interpretation of at an airport, that can include areas that are not just on the parcel owned by the airport, like the government authority that operates the airport, and adjacent parcels. When you go to BWI or Dulles, there's facilities around the airport that are at the airport in the sort of your typical sense of what that could mean. So that is our point. And again, I hear the point about if you look at the co-location exemptions, it says on the rooftop of buildings, on brownfields. It doesn't say on airports. It says at airports. So it is different.
Well, on airports doesn't make any sense. I mean, you use the preposition that makes sense. And at airports, I mean, if there's adjacent property that's owned by the airport, I can understand your point that it also the airport owns parking lots or they lease parking lots or they have some relationship to a parking lot owner or they have. I mean, I can understand where you're making the argument that there's some connection somehow, whether it's a connection through contract, leasing, but these adjacent parcels have no connection to the airport.
I mean, it is correct. They're not, these are green fields, so they're not, a parking lot like a long-term parking lot, to Commissioner Barvet's question. So that's a fair point.
Right. Mr. Chairman, I don't understand how we can interpret this. I mean, in law school, I learned we had a case where was actually meant not, and we could go through that those machinations here. But this doesn't strike me as warranting an expansion at airports to include everything adjacent to the airport. It could also include adjacent to the adjacent lot, and we could just keep going from there. So, I'm sorry, Mr. Chairman, that doesn't make any sense to me.
Speaking as a former member of the legislature, I think what we probably had in mind was all that empty space we see as we're taking off and landing, not, the parking lots around. But that's just me, and I'm only one out of 141. Actually, out of nothing now.
Right. No, not nothing. So, sell yourself short. So, Commissioner Linton.
There's something to us. Don't worry.
That's right. Yeah.
Oh, I don't know that I have any questions, Mr. Chairman. I don't have any questions.
All right. So, I asked this question of staff. Maybe what Comico County's attitude about your project?
There's been no permit application, as we've discussed in other unrelated matters. The SO approval is kind of a first step. So, waiting. Obviously, the ability to apply for interconnection has opened things up a bit, but these projects are very early, so there's not been that communication.
All right. So, looking at page 6 of staff's buck sheet, which is this map that shows the airport property, the two existing projects, and your two proposed projects. I mean, what I'm looking at on the screen, it's colored, so the airport property is in blue. So there's this, looks, for want of a better word, an arm out to the left that sort of goes between the two existing projects and then touches, these two proposed projects, although, almost it's very extended, to connect you to the airport. I mean, give me a sense of what that property is. I mean, it seems strange to me that the airport property is kind of designed that way.
I don't know the history behind that. To me, it looks like a residual part of the property. Maybe before the airport was built, this is a farm field, and that was historically just part of the parcel. But I have the map up, and I see that.
All right. This developer, I mean, since you've been there, I mean, you have any thoughts on why the property is configured that way? I mean, I realize it's historic, but I mean.
Yeah, good afternoon, Chairman Hoover. Thank you for listening to our argument here today. We've spent a lot of time on this. I just like to say that the landscape's changing. So when we started this project in March, we purchased this land, and it was common ownership. The other two projects you see there were owned by the same individual. And as a typical developer, we asked about the other land. We asked about why he was selling it. We were unaware that these projects existed until the Public Service Commission let us know last week. So there's some evidence in the queue, but not 20 megawatts in the queue. So I've never been able to identify what was going on in those property other than the farmer who we share in common. But it is common ownership, has been for a long time. I can't tip. My experience with airports is they generally buy up some space around the airport for expansion purposes, which is one of the reasons likely you have an airport what do they call it, airport overlay district, so that they can expand as the airport expands. There's several ancillary buildings along Airport Road that are not owned by the airport, but would be considered at the airport. And you grow the airport as traffic grows, as population grows. You have private jets, you have commerce, and they have to grow. And they do pick up pieces of land to grow the airport. That would be my experience and understanding.
So if we don't grant you the waiver, apart from this discussion about a potential rulemaking, what's your next step?
Well, there would be one project remaining. The developer could pursue that project. There are some concerns now that we're aware of these other two projects that'll impact the cost to interconnect, and having the additional projects could help offset that by economies of scale. But there is that one remaining project that staff hasn't recommended denying, and presumably they could approve that after this.
Mr. Chairman,
Yes, sir.
I have a quick question for the
Go ahead.
company. So I'm also looking at this map. Was this land owned by the airport at some point?
Commissioner, I don't know if you can hear me. Commissioner, I'm unaware of the previous ownership before the gentleman we bought it from.
I mean, it occurs to me, well, I mean, now we're trying to sort of interpret an interpretation, but it may actually be useful to know whether this was
So
part of airport property at some point.
all right. So apropos to the one we dealt with before you guys got up there, is there any time sensitivity to this particular one, or?
There is less time sensitivity. A part of it is they can apply for interconnection, so they've been waiting, and so
Yeah, no, I understand that part, but
so there is some ability to.
But I don't need to. I don't need to decide this today, correct?
Correct, Chairman.
All right. So this one, 27 and 28, we're going to take under advisement and sort of take a look at it and see if there's a way forward. So.
And Mr. Butmans, can you get us information on the history of this property?
Yeah.
Yes, we'll see what we can dig up, and we'll submit a response to the bench data request.
Yeah, and Mr. Chairman, I think I'd like our staff to just define for us what these overlay zones are, just for my edification.
So we may have some questions for both the applicants and staff on more of the details with this to see if this is, related in some ways to the one we just dealt with, which was a unique one-off situation as opposed to creating a new precedent here. So before we adjourn the meeting, I do want to note, and I probably should have said this at the beginning, that this actually is the last Public Service Commission function that Miles Mitchell, our general counsel, will be participating in. And he did participate here, so we want to congratulate him on his retirement and enjoy riding off into the sunset, and best wishes. So with that, we're adjourned.